You are for the petitioner.
I'm for the petitioner item number 7.
The members have to be the consent of the other side. The learned counsel appearing for the petitioner, brief by item, prayer allowed. You want any fixed date here or?
On 2nd of April, my lord. With the concern of
Many
the
matters are
respondent.
there on 2nd of April. It will be possible. That was it, no? After Bihu will do.
Before Bihu, because before Bihu, lordship.
Before Bihu.
On
then in that case, 1st of April.
First of
April.
Must have blessed.
Lordship, I beg to mention item number 14. Due to a medical emergency, Lordship, the conducting counsel is unable to appear today.
Item number 14. Yes, what is the position of item number 14? Are you on interim?
Yes, Lord.
Oh, Mr. T. Borua.
A does, Lord.
A does. And the counsel appearing on Mr. A does. MS A does. Paid for an adjournment stating that due to some medical emergency, she had to let it go. However, it is submitted by Mr. Waterford at CD receipt. What you are going to retain or return back?
6-4.
6-4 you are going to retain or can it be retained? List the matter on 6-4. So and so. CD be retained till next date of listing.
Interim may continue.
Interim, yes. Interim be continued till next date of listing.
May I please, Your Lordship, I beg to mention item number 25. Due to personal difficulty, the main counsel will not be able to be present here.
25.
Yes, Your Lordship.
Who is the leading counsel?
A.R. Borua.
A.R. Same order between conflict. Fixed it after 2 weeks. It will be listed after 2 weeks. We cannot fix a date here.
Much obligation, Lordship.
As on a date will fix by the rate.
May I please, Lordship? I beg to mention item number 17, Lordship. Kindly adjourn for the day.
17.
17.
7.
17, Lordship.
Yes, what is the position of 17?
This year,
Are you on interim there? Because
No.
it is a charge sheeted case that I don't know. That's why I'm asking.
No, Lordship.
You are not on interim.
No.
At the request made by the learned counsel for the petitioner, matter is adjourned. Scanned copy of the TCR has already been received. After 1 week, no, it is a AB matter. First of April.
Lordship. Deeply obliged.
May I please, Your Lordship? I beg to mention item number 12, my lord. In item number 12, CD is there, my lord. My lord, because of my senior, some personal difficulty, my lord could not appear today.
Who is your senior?
SG Borua, my lord.
What are you going to retain the case diary here? You are on interim or?
No interim, my lord.
No interim is there.
And short date now.
6-4.
6-4. At the request made by learned counsel for the petition, matter is adjourned. However, it is submitted by Mr. Waterford at CD receipt. Retain the case diary till next date of listing. List the matter accordingly on 6-4. Okay, we are listing it on 6-4.
May I please, Your Lordship? Lordship, I beg to mention item number 15, Lord. 1-5.
1-5.
Lordship. The
Yes.
CD was called for, Lordship. I
Are
only
you on
came,
interim?
Lordship. Yes, Lord.
CD not received. Issue reminder. Interim be continued till next date of listing. List accordingly. Yes.
On my lord, 27th of April.
27.
Lord. Obliged, Lord. Lordship, FIR case 10, Lordship. Petitioner arrested on 10/2/26 for 2 days. Allegation of section 140 kidnapping, Lordship. And petitioner before your Lordship, accused number 2 and 3. And accused number 4 is an interim with another petition, Lordship. The basic allegation.
You are accused number 2 and 3.
Yes, Lordship. There is a lordship, Betelnut business friend, and all they went to the Meghalaya, and all they were detained. That accused person along with the informant's husband. Then they made call was made by the informant's husband, asking the money which is required to given this garden owner. When this accused number 2 and 3 came to collect out money, and the wife lost this affair, and some part of the affair is true lordship, admitted fact, and other he was all the accused persons were detained by this Meghalaya lordship. That's why 2 and 3 came to collect that money. In the minute they were arrested lordship. And therefore, yesterday, accused number 4 approached this court and he was granted interim lordship. And till now, 42 days lordship in custody.
Whether the person is now he had already been recovered or not?
Yes, recovered lordship. Recovered lordship.
Is there any recovered?
Yes.
Recovered.
Recovery only, he has submitted the recovered, only CD will reveal, otherwise.
It's recovered lordship. It's fairly submitted.
Maybe his submission may be recorded.
Yes.
Heard Mr. S.U. Amit, the learned counsel for the petition. Sorry?
Yes.
And also heard Mr. P. Botipur, the learned additional PP, appearing on behalf of state respondent. This is an application, section so and so in connection with so and so. Next part is submitted by Mr. Amit that the present petitions are innocent and they have not involved in kidnapping the husband of the present petitioner. However, it is the fact that these two petitioners, along with the other accused persons and the husband of the informant, was kept in Meghalaya, wherein they dealt with the business of Betelnut. But as the money was along with the husband of the informant, the accused number 2 and 3 visited to the house of the informant to collect money when the police was informed and they got arrested. However, the petitioners, the husband of the petitioner has already been rescued, and these two petitioners are in custody since 10/2/2026, and hence, considering their length of detention, they may be released on. One of the co-accused is also granted with the interim protection on his bail application, on his adjustable bail application. Next part, Mr. Botterfoot, the learned additional PP submitted that at this stage he is not in a position to submit as to whether in regards to you have submitted the forwarding here.
Yes, lordship. Forwarding report is there, lordship. Page 18, lordship. Page 18, lordship. Page 19 recovered the victim person lordship. Page 19 is mentioned. First paragraph. During the course of investigation, the matter was informed
Not in a
to the
position to submit. As to whether the accused persons are involved in this case and as to whether the victim has already been recovered or not. Next, we are hearing the submission made by learned counsel for both sides. I have also filled the case record. And from the forwarding report of these two petitioners, it reveals that the victim has already been recovered. So considering this aspect of the case and also considering the length of detention already undergone by the accused petitioners, I find that further custodial interrogation may not be necessary for the purpose of investigation in view of this. So and so, so and so. This Mankachar means
yes, lordship. Yes,
Dhubri.
yes,
No.
lordship.
CGM Dhubri or what?
CGM South Salman Lordship.
CGM South Salman.
Yes,
CGM South Salman. 30,000.
Madam. May I please, challenge this bail application, my lord, petitioner is apprehending of arrest, my lord, since court have issued summons on 2 to 3 occasions, my lord, and then NBW was issued, my lord. FIR is at page, my lord, page 16, my lord. Page 15, my lord, that is translated for PN.
My lord,
Original
declared
copy.
absconder also, my lord, PNA issued.
PNA already issued.
Yes,
Case record is to be collected. He already PNA is issued, na? So we have to call for the case record. Let us see.
My
The orders, have you annexed the otherwise order sheets here? Order sheets have you annexed?
Yes, my lord.
You have annexed the order sheets?
Yeah. My lord.
Okay.
Page 6 series, my lord, page 27 onwards, my lord.
Yes, yes, I have seen. Okay, then. Call for the scan copy of the this year along with the case diary. Registry will do the needful. Yes, whatever, when it can be fixed.
um,
Next date, can you tell us the next date?
33, my lord.
33.
33, my lord.
Before
33, then my lord,
before 33 is not possible.
my lord, it would be difficult. My lord. On 8th of April,
Because before 33 may not be possible. So
My lord, in
8
that, I may be protected. That is my hope.
no, PNA has already been
No
issued.
coercive.
PNO is corrosive action of question is corrosive action is not there because PNA is already issued. So 30, before 30, we are not in a position to give you any date.
Well-
So it will be after 30 only.
Well,
Yes, Botaku?
on 7th of April. my lord.
Yes, on 7th of April. 7th of April.
well,
Bora.
obliged.
April, between that. Will do.
May it please your lordship, a pre-arrest bail application.
Yes.
Here in this particular matter, my lordship, what has happened is that the informant happens to be one of the police personnel from the traffic department. And on the day of the incident, this particular informant, along with his friends, were attending a farewell ceremony of their colleagues. And then what has happened is that after attending the farewell ceremony, it was quite late, like almost before midnight. And then they came down, and then one of their friends had tried to start his scooty. And in the meantime, since they were already like maybe they have like it was quite late, and in that time he wanted to go to his place in a fast manner. So he started his scooty, but there was some default. And in the meantime, the scooty went and hit one of the pillars of the GMDS parking slot at Ganeshguri. So while that particular incident happened, two of the persons who were looking after that parking slot, they came to these persons, and there was some sort of a brawl and some scuffle. And in that particular incident, now it is alleged in the FIR. Now we'll go to the FIR, my lord, if my lord permits. It's page number 11, Annexure A.
Yes.
So in this particular FIR, we can see that there is a specific allegation against one of the alleged, that is Pranjal Das. And there was one more person, Nirmal Singha. Now here the petitioner, accused petitioner is Nirmal Singha in this particular bail application. So here he is praying that maybe because of the fact that he was present there and his name was also being included. And in the meantime, police is looking for him. So he has a total apprehension since his name is his FIR name now. Maybe police will arrest him if they find it, because the sections are non-bailable, cognizable and non-bailable. Attempt to murder is there, then it is voluntarily causing grievous hurt, and then common intention is there. So now his main apprehension is that he was only present at that point of time with that accused who has actually, maybe it is alleged that he has hit one of this informant with some iron rod. That will be only clarified after we get the CD, because we do not know like at this point of time what has happened. But there was no prior sort of intent on anybody. It was a completely it was a brawl, because maybe because of the fact that this police personnel, they were also being a little bit, maybe they are not high, because they had just come down after attending a party. And then this person, he went and he hit the pillar. This particular GMC like parking personnel, the petitioner is working as a GMC parking personnel. So he has come to confront, maybe there was some sort of confrontation, there was some sort of argument, some sort of brawl which led to a quarrel, and there was some scuffle. So purely it is accidental in nature actually.
But now the fact that there is a specific allegation against the co-accused Pranjal Das regarding like he has come with iron rod and has hit the informant, and as a result, the informant has been inflicted with injury, and he had to undergo some stitches also. So, considering the fact that since it is a non-bailable and cognizable offense, I am praying before this lordship that in the meantime, CT may be called for, and this person, this accused petitioner, this Nirmal Singha, may be protected so that as an interim, so that he can go and he can give his statement, record his statement before the police personnel, and he could exactly say what has happened on that very day, on that particular night, my lord. So this is the only humble prayer from this particular petitioner. And then item number 4, lordship, is item number 4 is also there of the same police station, of the same case, where this second accused, the main accused, this Pranjal Das, he is also prayed for anticipatory bail in item number 4. So praying that in the meantime, CD may be called for, and this particular person, this accused petitioner in item number 3, he may be protected, my lord, so that he can go and he can record his statement. And after recording his statement, the facts will be cleared, my lord. Exactly what has happened on that night, because from the incident had happened on the night of 8th of March, and from 8th of March, now these two persons, they are fearing that the police are looking for them, and in the meantime, they are also trying to.
Well, here from the FIR, it reflects that meanwhile the said person Pranjal attacked me with an iron rod and struck me. And so mainly, although allegation is there only against my lord that Pranjal, he attacked with an iron rod, my lord. The petitioner number 3 and 4, my lord, both are two accused persons. Otherwise, Pranjal Das, it seems that my lord, he mainly struck the attack with that iron rod stuck on his head.
They were basically
Both
doing
were-
their duties,
otherwise,
my lord.
both are FIR named accused and both were present at the. But specific allegation against Pranjal.
Heard Mr. W. or made done in answer for the petition. Also heard Mr. P. Waterford, done in addition PP appearing on behalf of state respondent. It's an application of section students connection students. Next submitted by Mr. Mehdi that on the night of the incident, the informant and his friends, after having a farewell party, was coming down when one of his friends about to start his scooty when, and in that process he hit the vehicle in the pole, and when some of the two persons, basically the present petitioner along with other, came, and there was a who was on duty of the GMD parking, and there was a quarrel and scuffle between two groups. The present petitioner, named though the present petitioner is an FIR accused, he had not committed any such offense as alleged in the FIR. However, in that scuffle of the quarrel, one of the victims sustained some minor injuries. The petitioner is ready and willing to extend his cooperation in the further investigation of this case if he is granted with some information. Next, Mr. Bottom. The learned additional PP submitted in this regard that as per the FI, one person sustained previous injury on his person, and the present name of the present accused petitioner is also mentioned in the FIR, and hence he insisted to call for the case diary to know the actual facts. Next, considering the submission made by land all other aspects of the case. This court is of opinion that an interim protection may be provided to the present petitioner till receipt of case diary. It would 10 number 2, huh? In 3, you will be under interim protection when it can be fixed.
On my lord.
Second.
Second, 1st of April.
1st of April, he will be on interim.
Then I think both may come otherwise my
Together.
lord, same CD, my lord. Or any other date next on 6th of April.
No, they will be under interim, maybe after Bihu.
Yes, after Bihu.
In both cases, my lord,
In both cases,
both-
interim will be there. In number 4 to
Then, my lord, on 27th of April.
Yes, 20.
24 to অলপমান বেলেগকে লিখিব। Just so and so submitted that accept কি লিখিব তাকে লিখিব Mr. Medhi, sorry, Mr. Amedhi, Tilane Council for the petitioner further submitted that though the name of the present petitioner is mentioned in the FIR, but the FIR and admittedly there was a scuffle and altercation took place between the parties, but the petitioner had not committed any such offense as alleged in the FIR. However, the petitioner is ready and willing, বাকি এনেকে মিলাই দিম। Whatever submission. 27.
For daily item number 9.
Obliged.
Please. Can copy beside you?
Nine, my lord. Scan copy of PCR not yet received.
I think you are on interim.
Yes, Lordship. Since 4 to
Scan copy of the DCL is not yet, as we will the office to issue remind irresistible to the name. Yes, what?
On, my lord, 28th of April.
It's
30, my 30
30 April.
April, my
30 April, huh? 30th of April. And interim be continued till next.
Lordship.
Please, Lord. My lord, here in this case,
Just
LCR
and
was
here we
called.
have received this scan.
Minus.
My lord, this is regular bail application, my lord. What happened, my lord? Due to out of station, I would not able to continue my presence. As such, the learned court will issue 10 BW against me. And PNA also, my lord. Finally, on the strength of NBW and PNA, I have been arrested, my lord. Now, out of 10 witnesses, my lord, 4 witnesses examined, my lord. My lord, I am behind the bar since 267 days, my lord. At any condition,
How
one
many
more,
days?
sir. 267 days.
267.
267 days. So, my lord, kindly one more chance.
How many
maybe
witnesses examined?
4 examined, my lord, out of 10.
Out of?
Out of 10.
LCR is there.
Yes. What you
No,
sir?
no, it's
My lord, so far as the evidence of PW3, who is the father of the deceased, my lord, so there is no any eyewitness, my lord. My lord, there is no any eyewitness, but there was a scuffle between 2 brothers, and finally the elder brother assaulted on the younger brother, and finally he died. So far as the evidence is concerned, my lord, there is no any direct evidence against me.
Who are you?
My lord, I am the elder brother of the deceased, my
So you are the main accused.
lord. My lord.
not necessary for any direct evidence, my lord. He has led to the
You are the main accused.
my lord, he has led to the discovery, my lord. X was recovered. as
X
is
was
shown
recovered,
by
my
the-
lord,
Shown by the accused person, my
which
lord.
was also in my hand, my lord.
Not
I am not
not,
suppressing.
not in the bed,
No, no, no.
under the head.
I have handed over the X to the police. So far as the evidence. I am not suppressing. So, my lord, one more search may be given, my lord. I am a local person, my lord. Due to financial hardship, I was out of station for living with my family. That's why I could not able to continue my bed. Only one more.
My lord, on the death of Sergeant Prem, my lord, 3/8/2023, he was not available in the court, my lord. And that's why NBW issued and PNA issued.
Almost 1 year.
2 times they have filed their bail petition before the court below, and considering the conduct of the accused person, bail was rejected. Here also, my lord, he is the person who assaulted his brother, my lord, with an X, and died. Subsequently, he died in the hospital, my lord. And witnesses are also implicated him, my lord, from whom the X was also, as per his, my lord, lead to the discovery, my lord, it was recovered. From the witnesses also said on that line, my lord. And only out of 10, my lord, only 4 witnesses examined. And in the order that 9/1/2025, PW5 doctor was examined for video conferencing. But that record is not available in the record, my lord. And that statement, and on that day also PP also paid for other evidence, my lord, regarding the doctor, my lord, PW5. That statement is not available, deposition not available in the record, my lord. Otherwise, my lord, some of the material witnesses are yet to be examined, my lord. My humble submission is not at this stage, my lord. His conduct is very bad, my lord. After charging of the claim, my lord, he is not cooperating in the trial, my lord. And if he is released on bail at this stage, my lord, he will plead him, as he is the main person for, my lord, disease, for whom he died, my lord, his brother, own brother. There is the chance for, my lord, tempering, and also plead, chance of plead.
My lord, can I read
That
the PW3, my lord, for a moment, my lord? I have not written the FIR, but the signature is mine. The police had taken my signature on the day after the death of my son, after they called me to the police station. Accused is my younger son, and this is Diganto Das was my elder son. The incident had occurred about 2 years back. On the date of incident, I was not at home, and I do not know what had actually happened. The deceased used to drink and also take ganja and create scenes. There was some trouble between both of them, I have heard. After hearing of the incident, I came back from Gauhati. My wife had taken him to the hospital. I did not go to the hospital as at that time we were informed that my son Diganto had died. I do not know when the affair was done. I have heard that the deceased Diganto had fallen over the stones and had injured himself. While both the brothers were chasing each other. The accused Montu Das has not killed Diganto.
Lakshmi, kindly paste PW1.
All
PW1.
other witnesses are hearsay witness. There is no any eyewitness.
PW1 is the
PW1.
most important.
Now I am reading the
It is a
PW1.
development, my lord, father, my lord, PW4, my lord.
Yes, you know, see, the question is this one sign already died.
My lord.
My lord,
So definitely he will try
My
to
lord.
protect his.
My lord, that is the
That's the main
PW,
issue.
my lord.
That is the issue. That's
My
why,
lord,
though the family members, though his
My
father, still he will protect.
my lord.
My-
That is why he
Definitely
developed.
evidence is on that manner.
I have also gone through 161 statement, but on that 161 it is clear.
Hmm.
But in deposition before the court, my lord, his subsequent developed, my lord. Only lordship also, my lord, to
My lord,
protect
only
this.
one
Maybe.
My lord.
But you're saying that he was absconding.
My lord, my lord.
My lord, due to financial hardship, I went at Meghalaya with my family. That's why I could not able to continue.
From the framing of charge, my lord. 3/8/2023, and he was arrested on, my lord, 3/06/2025, my lord.
Warrant was issued on
On
14/7.
on the strength of PNA and
My lord,
NPW.
admit, my lord. On the strength of PNA, I have been arrested.
Or Mr. A. Paramshan, the done of the petition, the done it, petition PPA, can copy of the detail. Submitted by Mr. Paramat that the present accused petitioner is in custody since last 67 days. And after he got arrested, strength of the further submitted only due to some financial hardship. He, along with his family, went to Meghalaya to earn his livelihood, and there was no intentional negligence on his part in attending court. Mr. Paramanik further submitted that out of 10 witnesses, 4 have already been examined and the remaining witnesses are yet to be examined. However, the petitioner being the local person, there is no chance of responding. Rather, he will extend his cooperation in the external. He will appear regularly on each and every date to be fixed by the court and to contest this. he further submitted that the PW3, the own father of the deceased, did not depose anything against the present petition, and he is not the eyewitness to the prosecution. Next. Mr. Sharma, the learned additional PP submitted that out of 10 numbers of witnesses, only 4 been examined, and PW5, that is the doctor, is stated to be examined through online. So his statement is not available in the case. And Mr. Sharma further submitted that that the accused was absconding since 3/8/2023 from the date of framing of charge, and subsequently on the strength of MBW and PNA issued against him, he got arrested on 30/06/2025. There are many material witnesses are yet to be examined, and hence the chances of tampering with the other witnesses, as well as the probability of absconding of the accused petitioner cannot be denied at this stage. Mr. Sharma accordingly raised objections that bail may not be considered. Hearing the submission made by the evidences so far recorded by the prosecution, it is seen that there are supplementing materials against the present accused petitioner in the evidence of the DWs, and who also led the police in recovery, the police for discovery of the murder weapon, that is axe, through which the murder was also. Apart from that, it is also seen that the accused, there was a delay of 2 years only for the only for absence of the accused petitioner, who absconded at the time of framing of charge, that is from 3/8/2023. The court took all endeavor to procure the attendance of the accused petitioner, and somehow on the strength of MBW and PNA, the accused got arrested on 3/06. So considering the accused petition and the probability of absconding as submitted by the learned petitioner cannot be outrightly rejected. And apart from that, it's there are apart from that, the probability of also tampering with the other material witnesses also cannot be denied at this stage. In view of this court is of opinion that the granting bail to the present petition at this stage may not be justified. Accordingly, the present petition stands dismissed. Your petition stands dismissed at this stage.
Highly obliged.
Wait, please, Your Lordship.
She did not receive money.
In this case, Your Lordship, may remember Your Lordship had fixed a short date because in this case, initially the petitioners had lodged an FIR because one of their family members was attacked with a dagger on his face. So in that case, the accused persons were arrested. Now those accused persons also lodged a counter FIR against these petitioners, alleging that they had attacked them. In that case, this honorable court was pleased to grant them interim protection. After obtaining interim protection, when they went to the police station, they were arrested in another case. In that case, this bail application had been filed. So Your Lordship was pleased to fix a short date. If CD has not come, may I pray, my Lord, it can be taken up on?
No, you are saying that in the present case, they were initially on interim protection.
No, not in
No,
the present case.
another case.
Oh,
There are
in
three
another
cases,
case.
my Lord. First case was lodged by us, in which they were arrested. In their case, we were granted interim protection. That was 766. When we went to police station with the interim bail order, then we were arrested in another case. Another case which was lodged by one of their family members. That is
What the allegation is that?
similar allegation, my Lord, of attacking Marpit, my Lord. Basically, allegation is of
But
They have
the
invo-
cause of actions are different.
They have given two different days. One is of the evening of second, and this FIR they mentioned of third morning. Because of that, your lordship was pleased to call for that case.
Second or
Six. Because
detention is
second was what date it is? Six.
6 for the
Third. No.
email message.
33 today is in custody for 33 days, my lord. So if your lordship may be pleased to fix it on 1st of April, my lord.
Yes, you try to get
My
this diary.
Second, we will try it on second.
First or second?
This
Second, there are many matters.
Minor.
Let
First
it be
minor.
on first of April.
First of April.
First, man.
Signal should be made based on one. Let us see.
My lord.
We have received the case diary.
Petitioner is on interim bill actually. Last notice, I'll see the last order. Petitioner was
Petitioner
directed
appeared, my
to
lord, statement recorded, my lord. There is in her statement, she, my lord, implicated the accused person. Age of the victim is 20 years. My lord.
it is 20 years lordship. I'll see the FIR. He is the consenting lordship. Page lordship kindly see vernacular page 11 lordship. This is a vernacular language lordship. Vernacular is very legible to read lordship. Page 11 lordship.
Yes, yes, okay, then you are for the accused number 2 and 3.
No lordship. Accused number 1.
Only one. Sorry.
Sohail Mahmood is the accused number 1.
Oh, yes. Lordship, the victim was 20 years. He also 20 years. I have lordship annex his admit card page 13 lordship.
No, we are not disputing it.
Yes.
She may be a major, but
Major.
you cannot rape
Yes,
a major girl
yes.
also.
No, lordship, kindly see the FIR. May I read, lord?
No, no, you are saying you're basically stretching on the
Yes, in her one.
thing,
Yes,
but
yes.
that is not the case. Even
Otherwise, he is
major can be
lordship
raped.
cooperating lordship with the investigation.
Is what any
Yes, my lord, from her 183 BNS, my lord, she implicated the accused person. She stated that on the pretext of marrying her, my lord, the accused person committed rape. And my lord, on the day of the incident, my lord, while she was coming from his my lord college, on the day that incident occurred, my lord. And thereafter, my lord, both the families met, and my lord, they assured to marry the victim. Later on, my lord, they refused.
Because the marriage did not taken place, that is why the FIR has been lost. In the
And
FIR
now,
itself.
as per her statement, they are trying to marry the accused with someone other. That is all.
trying to marry.
Yes.
Lordship, my contention is that, lordship, at that relevant point of time, the petitioner, he also not attained the age of 21 years for marriageable age, lordship. That is why marriage could not taken place.
Yeah, he
Still, there
appeared,
is a
my lord,
possibility,
statement
lordship.
recorded.
Administered agent and the land and also what the land this is an application city receipt submitted by Mr. President during the order of MP had already appeared before the I cooperated with the investigation and his statement is also recorded. The contents of the FI is representing that the relationship was consensual and the accused petitioner could not marry the victim as he did not even attain the age of age to for married not even attain the age of 21 years to marry. However, the petitioner is still ready and willing to extend his cooperation in the further investigation of this case if it is granted with privilege of witness. Return a petition be submitted in this regard that accused petitioner appeared before the IO and his statement is also reflected. This however, he submitted that the victim brought sufficient implementing materials against the petitioner in her statement recorded under section 183 BS. Hearing the subject including the amendments in the case that this court is of opinion that the petitioner deserves and that the custodial condition may not be necessary for the interest of the investigator. The petitioner is thereby provided with the privilege of pre-arrest. Accordingly, the order of interim granted to the petitioner dated 5/2/26 is hereby made absolute with same.
May I please, your Lord? As per interim order, I have appeared before the police station and recorded my statement. And now CD was called for murder. The allegation is that driver himself admitted that he has done the mischief, my lord. But even the 35 notice was issued to me. That's why I obtained bail order before your lordship, and I appeared before the police station. But I don't know why CD has come. I do not know why. I was served with the notice under 35 and 36 both.
Well, case they received well, at the time of granting interim, the argument of my senior was that he was a laborer. Man. But during my lord, from the CD, it appears that he is the receiver of all those bitumen. Man. He is the owner of that Godam, my lord. One initially, that driver was arrested. Thereafter, one Amir Hussain, and my lord, from his statement that Amir Hussain sold all these my lord bitumen to the present petitioner.
But the driver does not disclose before the owner.
Investigation is still going on, my lord. It seems from the my lord, his statement that he is not the laborer, he is the owner of my lord one এটা ব্যৱসায় প্ৰতিষ্ঠান কলিয়াবৰ চুলুং নলতলি আছে প্ৰতিষ্ঠানত মই নাথাকো so he is the owner of that my lord, one of a godown my lord and in one Amir Hussain he has stated that থকা বিটুমেন গুদামত ইছাদ আলী লোকজনে কিনি লয় হি ইজ দি ইছাদ আলী মই মোৰ কাৰখন গুদামৰ বাহিৰত ৰাখিছিলোঁ
Then 411 will be there against me.
so he is
Only
not the
411.
laborer but he is the purchaser so 3172 is also there in the
Will it be applicable?
yes purchaser of the still
The 411, that's I say, old section.
3172 of the BNS
That is new act.
new act.
But I have already cooperated with the investigation. And those goods, I have no information that it has been sold to me, but he never disclosed to me that he is the purchaser of the goods. But the audacity of the driver who has admitted before the owner, yes, I have done it. I have converted.
Done it, sold it to you.
Yes,
That is
madam.
the case.
But I even then, assuming that I have purchased that, it is, I had no idea that it was a stolen property.
Who was stolen then purchased by you? You have very much aware of about that fact.
The investigation is still going on he has appeared statement recorded
Heard Mr.
but
S.C.
he is not the
Biswas
laborer man.
Heard Mr. S.C. Biswas and the concept of petition. People. Delaney petitioner BP Prem city receipt. Mr. Biswas Delaney counsel for the petitioner submitted in this regard that the petitioner and he is simply working as a laborer. He is no way connected in the arrest of him. Rather, the driver of the vehicle also admitted regarding the theft of the bitumen. But as the petitioner received the notices under section 33 and even 36 BNSS, 33 and even 36 BNSS, he paid for the receipt of his debt after obtaining the order of interim bail, he appeared before the eye and cooperated in the investigation. Next, Mr. Bott done investigator that from the materials available in his diary as well as the statement made by the present petitioner with person. It is seen that he is not the labor but the owner of a godown wherein he used to receive the stolen bitumen and for which the section 3172 is also registered in the present case. Case is still under investigation. However, it is submitted by Mr. Bott. The petitioner appeared before the eye and cooperated in the investigation. Proceeding the submission made by the materials available in the case record, the conduct of the accused, and that to the interrogation when be required at this stage for purpose of investigation. In view of this, the order of interim arrest bill dated 5/03/2026 is hereby made absolute with same terms.
My lord, in
You are for the respondent.
I'm for the respondent. In the morning, they have took time for adjournment from us, but they have not
From
appeared.
you,
From
how they can take adjournment from you?
no, my lord, they have taken consent from us.
Achha, but
They-
they have
they will-
appeared before
They
us.
will mention for adjournment, but they will not mention.
No, they not.
But my lord, in this case, we have some urgency, my lord. Kindly before Bihu on 6.
None item number 5. None appears on call for the petition. Partner Mr. B. Puragamai did not need for the. It is submitted by Mr. Puragamai that matter is then accordingly he paid short. Yes, before Bihu ki baat hai nahi.
On 6, my lord. Only small,
Small,
Small
it
point.
is small for you. We have to go through it.
just my lord,
Yes, 20. 20 is the open day. Huh? Immediately after Bihu 20.
20.
Because prior Bihu 5, 6, 7, most probably many matters have been fixed. 8,
On 20,
realistic,
my
as it-
senior will not available. On 20, my senior will not available. On 24, my
20 or 24 then.
first.
Yes, 6.
Yeah, Mr. Lord.
This is they filed a complaint case against us. We are all the director of the company. So Lordship may kindly peruse the complaint they filed. That is page 16 for a moment.
16.
16. From para second, I am reading, Lordship. That the accused company is the regular customer of the complainant for farm since long and used to purchase diesel from the complainant farm from time to time on credit basis and used to pay the amount in installment. In this way, a huge amount of money amounting to rupees 60,000 so and so only became due to be paid by the accused to the complainant firm. Be it mentioned herein that all the accused person directors are fully involved in the day-to-day business affairs of their company. That on several requests the and demand of the complainant, the accused on 25/8/2019 issued a check bearing number so and so, dated so and so, for rupees so and so, only drawn on State Bank of India, 80 Road, Gauhati, favoring the complainant firm as part payment against the aforesaid existing outstanding
business liability and the complainant on good faith accepted the said check. That the complainant deposited the aforesaid check in his bank, namely Central Bank of India, Ulubari branch for clearance, but the complainant banker on 15/11/2019 informed and returned the said check unpaid to the complainant along with the check returning memo showing the reason funds insufficient as mentioned in the check returning memo dated 14/11/2019, as the said check was not honored by the accused bank. That the complainant finding no other alternative issued notice dated 25/11/19 posted on the same day through its lawyer on the correct address of the accused person demanding the amount of the dishonored check from the accused person within 15 days from the date of receipt of the said notice, and the same was duly received by all the accused persons on 26/11/2019, 28/11/19 respectively. That the complainant waited till the mandatory period of 15 days from the date of receipt of the said legal notice for the payment of the check dishonored, uh, bu- but the accused person did not turn up, respond, nor made the payment as asked for. Even they did not bother to send a reply of the said notice, legal demand notice. That the complainant begged to submit that on account of the non-payment of the amount which was due them and arises from the dishonoring of the check by deliberate and willful default on the part of the accused persons, the complainant has to suffer irreparable loss, monetary loss, mental agony, and unnecessary harassment. Therefore, Lordship, check was dishonored. Your Lordship will find the check, that is page 55. That is signed by the managing director, Anantacharan Nayak. That is the complaint was filed against the Anantacharan Nayak and four others directors. Page 55. Now, Lordship, here from the complainant, bare perusal of the complainant, nowhere it is stated that how we are involved in the said offense. We are merely a director. We are not responsible for the day-to-day affairs of the company, as stated under section 141 of the NI Act. For a moment, Lordship, I just read 141 of the section of the NI Act. Offense by companies, Lordship. 141 of the NI. If the person committing an offense under section 138 is a company, every person who at the time the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. So here, Lordship, it is clearly mentioned that merely a director cannot be liable. He should be in charge and was responsible to the company. So in the complaint itself, nowhere it is stated that how we are involved. It is drawer of the check who is only responsible. He has signed the check. So our liability is limited. We are merely a director of the company. And
Merely director means what you are saying.
we are director of the company.
Directors, what merely
Director.
directors? That-
Lordship, for a moment, I just
associated with the company's activities and all.
No, I just placed one judgment, recent judgment of the Supreme.
Case of mayor director. You were director.
It is Lordship recent judgment. Negotiable Instrument Act 1881, Section 138 and 140 of the Companies Act, Section 34, dishonor of check, offense by company. merely because a person is a director of a company. First paragraph, Lordship. First, no, note, it is a note, footnote.
Acha, note.
Note.
Acha.
Company section 34, offense by company. Merely because a person is a director of the company, it is not necessary that he is aware about day-to-day functioning of company. Simply because a person is a director of the company, it does not necessarily mean that he fulfills twin requirements of section 34(1) of the Act so as to make him liable. A person cannot be made liable unless at the material time he was in charge of and was responsible to the company for the conduct of his business. There is no universal rule that director of the company is in charge of its everyday affairs. To escape liability, they will have to prove that when offense was committed, they had no knowledge of offense or that they exercised all due diligence to prevent commission of offense. Merely reproducing words of the section without a clear statement of fact as to how and in what manner a director of company was responsible for conduct of business of the company would not ipso facto make the director vicariously liable. There is no abatement to the effect that present appellant is in charge of and responsible for day-to-day affairs of the company. It is also not the case of the respondent that appellant is either managing director or joint managing director of company. Abatements made are not sufficient to invoke provision of section 141 of the NI Act qua appellant. Judgment and order passed by High Court quashed and set aside and complaint case quashed. It is a recent judgment, Lordship, passed by the Justice B.R. Gabay and Justice Sandeep Mehta. So my case is squarely covered by this.
Just
Here-
explain
here
how,
they-
how you are not related with
Now
the
here
business.
they fail to mention anywhere how we are responsible. They merely stated that we are the director of the company. So we never signed it. We are not in anywhere. Our signature was there in the companies. They have provided in the complaint petition. I have annexed all the documents where they know where it is. Our signature was there. So
Your signature was not there.
how we are involved? It
In
is
where you're saying your signature was not there means?
no means that we have sent the material to them. We are responsible for the conduct of the business. So nowhere it is proved that we are liable for the day-to-day affairs of the company. They are only the signature made by the managing director of the company. Then, Lordship, another aspect of the case that company is now defunct because the company failed to pay the outstanding amount. Therefore, thereafter the NCLT has passed an order. Company is no longer is in existence. So our liability for the director is limited now. It is the doer of the check who is responsible for all the acts of the company. It is we have also annexed the order of the NCLT, Lordship. That is page 71. The operative part is 99, page number 99. Para 15. This adjudicating authority hereby appoints as proposed by the FC Mr. Vishal Giswal Join, office so and so, interim resolution professional. The interim resolution professional is further directed to make public announcement of moratorium in respect of corporate debtor soon after receipt of an authenticated copy of this order and to act further as per the order direction issued by this adjudicating company and follow the provision under section so and so, relevant provision of insolvency and bankruptcy code. The IRP has to submit assignment declaration before the registry within 2 days from today. Therefore, our company is taken over by the resolution professional. The company is activity is totally stopped now. Where company is no longer is there, so 141 is not applicable here. The director of the company, when company is there, the director will come. As per section 41, as well as the company. Lordship may again, I just read once again the section 41. If the person committing an offense under section 138 is a company, every person who at the time of offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed. So company required to be there. For the, if the director is required to be prosecuted, the company should be there. If company is no longer is, company is defunct, so our position as a director is no longer in existence.
Then what is your suggestion? How they will?
So no,
their
as
money?
as per this judgment, we are not responsible, Lordship.
So who will be responsible? Who will
So
refund it?
those one who
Only
signed,
managing director Bichara, he will be responsible.
no, one who signed the,
That is the managing director. he
yes,
has
yes,
submitted.
managing director.
So he will refund the entire money now.
Yes, because
From
he,
where? From where? If company is not in existence, from where he will refund the money? Bichara, he put his signature on the
no,
on behalf of the
if
company.
no,
only.
it is
Now where from he will refund the money?
as per the NI Act, it is the drawer of the check who is
No, yes, I
responsible.
can understand now how where from he will company, because on behalf of the company only he issued the check in the day-to-day activities while dealing with. Now how, from where he will pay? Anyway, so you are saying that you are not responsible as a
But
director.
as per the judgment, there's no abatement was made against us. This is my humble submission, Lord.
May I please? First of all, Your Lordship, they have not come, they have not approached this honorable court with clean hands. They have completely given a false statement. They have concealed the material facts of the case, Your Lordship. First of all, the address given by them is totally wrong. False address they have given before this honorable court. Because at the same address, PNA and NBW was issued by the learned court below, and they are absconding. In the lower court below, they are absconding. That's why PNA has been issued, Your Lordship. And again, they have given a false address in this honorable court. And they have suppressed that material facts that in the lower court, they are absconding and PNA has been issued. Nowhere it is mentioned in this petition, Your Lordship.
The petition was filed earlier, Lordship. How?
No, at that time already it was issued. And they have come to challenge this case now at the year, in the year 2000. But in the year 2019, notice was issued to them. They have received the notice. And again, in the year 2021, on 17/2/21, cognizance was taken against all the petitioners. And they have been summoned. They have appeared before the lower court and they prayed for time. But again, they started not appearing in the court. That's why the PNA and the NVW was issued, Your Lordship. So unless and until they will appear with clean hands and with they take the bail, how can they come before this honorable court on the false address and by suppressing the material facts, Your Lordship? And regarding their involvement, that they are telling that they were not involved, that they have to prove in the trial, Your Lordship. We will prove in the trial that they also are fully involved in the day-to-day affairs of the company. And it is the averment only. We have mentioned in our complaint petition as well as in our evidence that all the directors are involved in the day-to-day affairs of the company. That is sufficient, Your Lordship. In this regard, I am giving a judgment of the Honorable Supreme Court, Your Lordship. Lordship, kindly peruse para 4, second line, Lordship. It is settled law that the magistrate at the stage of taking cognizance and summoning is required to apply his judicial mind only with a view to taking cognizance of the offense, or in other words, to find out whether prima facie case has been made out for summoning the accused person. The learned magistrate is not required to evaluate the merits of the materials or evidence in support of the complaint. And again, in para 6, Your Lordship,
defense that may be available or facts aspects which when established during the trial may lead to acquittal are not grounds for quashing the complaint at the threshold. At that stage, the only question relevant is whether the averments in the complaint spell out the ingredients of the criminal offense or not. So averments is there, Your Lordship, in the complaint petition as well as evidence, averments are there. It is only in the trial court it will prove whether they were involved or not. They have to prove that they were not involved. Because without facing the trial, this honorable court cannot decide whether they were involved or not, whether they are responsible or not. So it is a completely fit case, Your Lordship, that their petition may kindly be rejected, Your Lordship, at this stage. Because the correctness or otherwise of the said allegation has to be decided only in the trial. In the para 9 also it is written that we are of the considered view that the High Court ought not to have set aside the order passed by the learned trial court issuing summon to the respondent. A perusal of the complaint discloses that prima facie offences that are alleged against the respondent, the correctness or otherwise of the said allegation has to be decided only in the trial. At the initial stage of issuance of process, it is not open to the courts to stifle the proceeding by entering into the merits of the contention made on behalf of the accused. Criminal complaints cannot be quashed only on the ground that the allegation made therein appear to be of civil nature. If the ingredients of the offence alleged against the accused are prima facie made out in the complaint, the criminal proceeding shall not be interdicted. And regarding the NCLT order, Your Lordship, the learned court below has already decided this board. In the court also, learned court below also, they have point out at this aspect of the case, and on the basis of the judgment of the Honorable Supreme Court, Your Lordship, that petition was rejected. Kindly peruse, Your Lordship, page 103 of the appeal petition. 103. That the order of the lower court dated 2010-2022. Lordship, I am reading just last 3 paras of the first page. Per contra, learned counsel on the strength of the judgment in P. Mohanraj versus others submitted that the directors of the accused company are statutorily liable under section 138 of the NI Act, and the moratorium under section 114 of the IBC is only applicable to corporate debtor. So the moratorium is only applicable to corporate debtor. Still the directors are liable. And on this ground and on the basis of the judgment of P. Mohanraj of the Supreme Court, Your Lordship, their petition was rejected because the corporate company may be excused, maybe a part of that moratorium, but the directors are still liable. I can give the judgment of this P. Mohanraj also. This Honorable Court, Supreme Court has clearly mentioned that there moratorium under would not cover the appellant in this case who are not a corporate debtor, but a director therefore. Thus, the impugned order issuing a proclamation under section 122 cannot be faulted with on this ground. The appeal are therefore dismissed. Okay. I have flag marked the relevant point. The moratorium is applicable only to the corporate debtors, not to the directors of the company. The directors are still liable. So unless and until they appear before the learned court below and face the trial, how they can say that they are not liable for the affairs of the company? When they are directors of the company, their name is there. We issued the notice to them. Party, they were also made party in the lower court. They have never challenged earlier. But now they have come with this petition, Your Lordship. So my prayer before Your Lordship that their petition may kindly be rejected at this stage. They may be directed to give a clear and correct address of them and appear before the learned court below to face the trial.
To dictate PC for quashing of the criminal proceeding, that is of NCR case number 668 of the 2023, filed before the Learned Court of GMFC, Kamrup and Gauhati. Next, submitted by Mr. Dalji, the present accused petitions are the board of directors, directors of the company, and they are not at all associated or involved in the day-to-day affairs of the company. The further submitted in the plain reading of the complaint petition itself, it is seen that there is no mention as to how the present petitioner, that is the directors of the company, are involved in the present case, in the present case. He further submitted that it is the managing director of the company, namely, what is his name? Managing director?
Anantacharan Nayak.
Huh?
Anantacharan Nayak.
But he has not been made party in this case.
His part is not required. The other
Anantacharan
Nayak.
Nayak. Anantacharan Nayak is the managing director who basically issued the check in question under his seal and signature. The present petitioners are the directors of the company, and they are not involved in the day-to-day affairs of the company and of the company. It further submitted that as per section 141 of the NI, the company's the NI. Every person of a company are responsible for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be proceeded against and may be punished accordingly. But to make out a case against a company or all the board of directors, there has to be some involvement, or the check in question has to be delivered in the day to at the time in the day-to-day business transactions, day-to-day business affairs. But there is no mention at all with regards to the involvement of the present petitioner who were the directors of the company. More so, the company is also defunct, and there is no existence of the company. The SCLT notice has already been served to the company. In that, in the above circumstance, the present petitioners are cannot be considered as a guilty for the offense committed by one of the managing director who issued a check in question. Issued the check in question. Mr. Next para, Mr. Dalji Learned, the petitioner also relied on a honorable export in case of Sushila Suscla Padmavati Silover. And so Supra reported by 2024 3
2024 SSC 230.
just a second, 2023
2024 SSC 230. 24 SSC 230.
SSC 230.
Yes, Lord.
SSC 230, wherein it has been observed by the Honorable Apex Court, they merely because a person is the director of a company, it is not necessary that he is aware of about the day-to-day functioning of the company. Citing the above referred judgment, it is submitted by Mr. Das that considering the case of the present petitioner in the same court, and the case of the present petitioner is also covered by the order passed by the Apex Court, and considering this aspect of the case, the criminal case pending before learned JFC Kamrup M may be set aside and quashed, who are merely the directors. Next, Mr. Jain, the learned, asked for the respondent of submitted in this document that in the FIR, in the complaint case, the only evidence has been made, but the details is not made in this case, and but the at the time of issuing at the time of taking cognizance, the magistrate is not supposed to also, at the time of taking cognizance, it is only required to apply the judicial mind of the magistrate to find out whether the prima facie case has been made out for summoning the accused persons. The learned magistrate is not required to evaluate the merits, or the materials or evidence in support of the complaint. In support of his submission, he relied on a decision of Honorable Supreme Court passed by division bench in case of Sau Kamal Shivaji Aforesaid Dialogue, so and so and another, reported in 2019 AIR SC 847. Mr. Jain further submitted in the above referred judgment also. It is held in para 6 of the judgment that para 6 to the so and so. So at this stage, without examining any witness or without coming any evidence, this present petition for quashing cannot be entertained at this stage, wherein the learned magistrate took the cognizance of this case only on the basis of the materials available and finding a prima facie case against all the petitions. Next, Mr. Jain further submitted that the cognizance of this case was taken in the year 2021, and after taking of the cognizance time of taking cognizance, they all appeared before the learned trial court below, but thereafter they remain absent, finding no other alternative. Learned trial court below also had to issue NPW and DNA against the present petition, who also misled the court by giving some false address. He further submitted that the issue of that the issue of a moratorium, issue of moratorium against the accused company has already been taken into consideration by the learned trial court below. And by order dated 20/10/2022, the prayer made by the accused company has rejected with the observation that with the view of the order judgment passed by the first judgment of Supreme Court in case of P. Mohan Raj versus P. Mohan Raj and others versus Messrs. Shah brothers, Ispat Viva and Aforesaid, so and so, wherein it has been detailed that the directors of a company are statutorily liable under Section 138 of the NI Act, and the moratorium under Section 14 of IBC is only applicable to the corporate debt. In support of his submission, Mr. Jain also relied on the safe judgment of Honorable Supreme Court, wherein Supreme Court. Mr. Jain accordingly submitted that there are sufficient materials, prima facie materials against the accused petitioners who are the directors of the company at the relevant time of incident, and accordingly they cannot abstain themselves from the liability of from the case record, and more so instead without going into the merit of the case and the evidence in detail, the case of the present petition cannot the case against the present petitioner cannot be paused or set aside at this stage. Next part. Hearing the submission made by learned counsel case record and the annexures filed along with the petitions. It is the fact that these petitioners are the directors of the company, and under Section 141 of the NI Act, they were made liable, and accordingly the case has been closed against them under Section 138 of the At the same time, it is also seen from the check issued in question that it was issued, the check issued in question, wherein wherefrom it is seen that the check was issued one of the managing director in favor of the petition, which was accordingly dishonored due to insufficient fund. Admitted position is that it is all the petitioners were acting as a director of the company, and unless and until every details have been brought in the before the court, it is not possible in the part of the learned magistrate as well as for this court as to the in regards to involvement of the present petitioner in the alleged offense. The or judgment which is relied by the learned counsel for the petitioner is basically passed after the recording of the evidence and after completion of the trial. But here in the instant case, it is seen that that at the very initial stage of taking cognizance, the petition for quashing has been filed, and hence to know the involvement of the present petitioner, and hence it is not possible to know the involvement of the present petitioner without recording the evidence or without proceeding with the trial. Further, it is seen that though the petitioners have filed the present petition, but they have absconding from the learned trial court below, for which the NPWA and PNA had to be issued against them, showing them against them because of showing against them, though the cognizance of this case was taken in the year 2021. To know the involvement of the present petition, uh, there has to be some sort of evidence to be recorded, and it is seen that the learned trial court below committed no error or mistake while taking cognizance against the present petitioner, finding a prima facie case against them who are the directors of the company at the relevant time. However, the petitioner will get a chance to place before the court in regards to the defunct status of the company, etc. But prima facie, it is seen that there is a sufficient prima facie matrix to take cognizance of the present petitioners were the directors of the company. So, in view of the above and considering all aspects of the case, this court is of opinion that there is an opinion that it is not the case to quash or set aside the entire criminal proceeding against the present petitioner by invoking the inherent power of Section 482 CRPC at this case. Your petition stands dismissed. State is there. Only state is there, only state. Okay. Yes.
My lord, this is a criminal petition.
Hmm.
There are two
It is already
FIR.
charged sheeted, I think.
Yes, there are two FIR in the present case. In the first FIR, my lord, I am not involved. Page, my lord, 17. In the first FIR, I am not involved, but my son is involved. In respect of POSCO case, my lord. Read with section 376 IPC. Page 17. And this case was succeeded along with two other accused. And the trial is going on. I am not involved in this case.
Yes.
Subsequently, my lord, subsequent FIR filed on 22/5/2025, page 28, my lord.
Hmm.
In this case, I am an accused. The ground is, my lord, if your lordship allow me to read, with the utmost respect, I would like to inform that the informant is headmaster of number 2 by Kopilipar LP School, and the accused person is a headmaster of Musabbir Ali Moktabi School. I took my school admission register book from school for doing some works. On 21/5/2025, at about 9 p.m. at night, the above named accused person came to my house to see something about the school admission register and asked me to allow him to see the school register. On good faith, I handed over the admission register. By that point of time, the accused person told me to supply water to him, as he is thirsty, and accordingly, I went inside the room and brought water and found that the accused person torn out the pages of admission register of 2013 and 14. This is the crux of this case. Torn out the pages of admission register of 2013 and 14. And immediately I stopped him with my hands but unable to stop, torn out the said pages. Taking the torn papers, accused given start of his bike and ran away from the place. Hence, I informed the matter to the president of the managing committee of the school. Thereafter, on 22/5/2025, at about 11 a.m., in the daytime, the accused used slang language against me and treated me to face dire consequences in front of the school student. This is the FIR, my lord. The main crux of this case, the present petitioner's son was involved in the, as alleged, involved in the POSCO case. Now, how to bring under the racket the father of the accused? This plan was conspired, my lord. Now, on 21/5/2025,
The informant here in the,
informant is the headmaster of his school.
no. Informant here in this case, he is also the informant of the other case? No.
No,
He's not.
no other case. No other case.
No. In the other case where your son is involved,
My son is involved.
this informant is not the informant.
No. My lord,
completely
in the first case, another informant is there, and in the second case, another informant is there. Two informants are there. First case, my lord, the grandmother of the victim girl was informant, and in this case, headmaster of the school was informant. In the same village, with utmost respect, my lord, there are two headmasters are there. In the same village, there are two schools are there. The present petitioner is headmaster of one school, and the present informant is a headmaster of another school within the periphery of the same village. Now, my question arises, my lord, to make a conspiracy, to make a plot as to how the present petitioner is to harass out of the family grudge, in respect of some family village dispute. This present petitioner was brought into the racket and filed the present FIR. Now, my lord, in the page 29, the informant stated that he ran away from the place. He ran away from the place after turning out the page of 2013 and 14 admission register. The next day, suppose, my lord, if I am a thief, if I committed a mistake, can I have that to appear before the complainant or some other else the next day? It is human conscience. Now, the informant is telling, writing thereafter on 22/5/2025, at about 11 a.m., in the daytime, the accused used slang language against me and treated me that to face their consequences in front of the school student. Is it possible? I turned out, I committed mistake, I have done something else, presuming that I have done something else. Can I have the courage to go in the school in front of the student and use slang language? This is a common knowledge, my lord. Everybody can guess the matter. Now, my lord, what did happen? After this charge sheet, thereafter, my lord, charge sheet filed, page 34. Operative part is, my lord, 37. In this charge sheet, my lord, further, second paragraph, my lord, further, during investigation, the turnout register has been seized by so-and-so in presence of witness, and seized procedure is videographed, was taken, and the seizure list article is produced before the Honorable Court for kind seeing. Later on, finding or revealing the new occurrence of crime in the instant case, the prayer has been made before your Honorable Court to take cognizance and submit the additional charge sheet against the accused, Zakir Hussain Tafadar, in the case, along with the so-and-so, and accordingly, Honorable Court allow him the same. Hence, finding sufficient evidence against accused Zakir Hussain Tafadar in this case, I am here with submitting the additional charge sheet number under 241(3)(24), read to section 3 of the PDP Act, prevention of damage of public property, my lord. And this 241 and 241 is under BNS Act, my lord. There is no POSCO. I am not involved with POSCO. I am now 56, 7 years, my lord.
Saying you are not involved.
Now, my lord, the honorable court, my lord, while taking cognizance in this POSCO case, my lord, page 42, annexure 7.
Yes.
Annexure 7, my lord, page 42. The, my lord, operative part is second paragraph, my lord. After hearing the learned counsel of both the sides, charges in writing under 241, 324, within bracket 3, and 238 of BNS and 3 of the Prevention of Damage to Public Property Act are framed against the accused Zakir Hussain Tafadar. The charges were read over and explained to the accused person, to which he pleaded not guilty and claimed trial. Now the case is proceeding. No evidence has been taken place. Tomorrow the case is fixed for prosecution witness. Now, the petitioner approached before this honorable court on the ground that since the charge was framed against him, whereas he is not at all involved with the crime, nor at all in any way related with the offense, even though the
This was a joint trial.
not joint, separate trial.
Hence, we go ahead for joint trial.
No, my lord, the separate case, PRC case number 1953, my lord, kindly have a look, page 45.
No, what is it? What?
Annexure is
Your lordship
45.
may kindly peruse order of the trial court dated, my lord, 2825, my lord, page 42. My lord, initially, my lord, what happened in this case? The present petitioner's son is the accused of a, my lord, POSCO case, that case, my lord. In that case, search sheet submitted against the son of the present accused person. Thereafter, after filing of the search sheet, what happened, my lord? The FIR, my lord, has been lost by the headmaster of that school. The present petitioner, who in fact to get some benefit in that POSCO case, probably, my lord, for obtaining bail or for some other reasons, my lord, he went to the, my lord, house of the residence of the, my lord, informant of that case, my lord, and to ask him to provide him the admission register only to look about the regarding some facts regarding the admission of the victim in that case, my lord. At that point of time, he torn out some pages of the, my lord, admission register, and thereafter, my lord, the present FIR has been lost by the headmaster of that school. And the present FIR is at page 28. And
It's
thereafter,
okay, I can understand. What is the 42 says that is it a joint trial or what?
regarding the present petitioner, the, my lord, charge frame under section 241 to 38, those are triable by the, my lord, CJM. So thereafter, my lord, those as distinct offenses, my lord. So, my lord, those case records were sent back to the, my lord, court of the learned CJM for, my lord, separate
Separate trial.
for separate trial. And thereafter, fix 16, 10, 25.
No, I'm not still following. The question is that earlier a case was registered against his son and some others for committing offense under POCSO and whatever. Now, in that case, admittedly, he is not the accused, or this petitioner is not the accused. And subsequently, as you have submitted that most probably there are something either to produce his son as a juvenile or to reduce the, I mean, to prove the victim as a major, most probably he has done these things.
Yes.
With a view to, most probably.
In that case, charge sheet already submitted. At that point of time, my lord, the present petitioner is not in the picture, my lord.
In POCSO.
Yes.
Yes, not
in the picture. Charge sheet submitted, my lord.
No, but why this order speaks about the present petitioner also? That's what I'm.
Your lordship may kindly come to page 28 of the present FIR, my lord, regarding the present petitioner, my lord. Page 28, my lord. The FIR of the present case, my lord, wherein the petitioner is involved, my lord. Informant is one Joy Prakash Sohan, headmaster, and accused person is Zakir Hussain Tapadar, the present petitioner.
My lord, with utmost respect, without prejudice to anyone, my lord, this Joy Prakash Chauhan is a TET teacher. He was posted in this village.
Whether he is a fake
my lord, by some people, influential people, use him for their vested interest, and he has lost the Izahar.
It's okay, no, but I'm just still not following. My question is that two FIRs were there.
Yes.
Initially, one FIR was there where charge sheet is also laid against his son committing sexual assault on a victim, whatever. So accordingly, page number 19 or 20 is the FIR wherein the case was registered and charge received.
Yes.
Subsequently, the another cause of incident was there wherein he went visited to the house of the one of the headmaster and
Yeah.
found the some pages and found it. So under PDPA Act, the
Yeah.
case has been registered under
Yes.
section some so and so.
Yeah.
My question is why in the case of this 2/8/2025, the case under which the POCSO is there, this also brought here,
No.
and as well as the case.
Thereafter, my lord, the learned trial court has directed the police to investigate into the matter and file additional charge sheet. Thereafter,
Oh.
in this case, my lord, additional charge sheet filed against the present petitioner, my lord.
After
After
special
separate investigation was done, my lord. After investigating the matter on the basis of the FIR at page 28, my lord, later on police has submitted, my lord, additional charge sheet against the present petitioner.
in the said earlier case only.
Not in the earlier person, on the basis of the present FIR, investigation was conducted by the police. Thereafter, after investigation, my lord, only on the basis of the present FIR, the allegation under section 238 to 41, and my lord, regarding those PDPP Act against the present petitioner, police has conducted investigation and filed charge sheet, my lord. Thereafter, my lord, against the present petitioner, my lord, only on the basis of that additional charge sheet, only the case registered against the present petitioner, Zakir Hussain Tapadare.
Why additional charge sheet?
Because, my lord, FIR, in this case, the present FIR has been lodged after filing of this charge sheet, totally a distinct offense. My lord,
Yes, distinct
cause of action. So, my lord, I hope CJM directed that to investigate into the matter regarding that allegation is that he, my lord, destroyed some of the pages of the admission register, my lord. Though offense is also, my lord, totally, my lord, different, my lord. And FIR is also lodged, my lord, on the basis of those allegations. Thereafter, on the basis of the, my lord, order of the trial court, police has conducted investigation, and thereafter, on these sections, police has submitted charge sheet against the petitioner.
So here in the POCSO case, there was an additional charge sheet also.
Yes, POSCO case, my lord, no way related with the present petitioner.
No, it is a distinct.
Distinct.
So no, the is page 43. If you go by, defense side already submitted that, followed by petition number under section 241 BNSS proviso, saying that they do not have any objection if the joint trial of all the three accused persons proceeds, though the offences are committed on different dates and at different places. Hence, we go ahead for joint trial of the accused so and so under section also for their distinct offense and the distinct charges. After hearing learned counsel of the charges in writing under section 241, 324, 3, 238 of BNS and 3 of the PDPP Act are framed against the present
petitioner.
So now there is a joint trial in that case.
Yes, initially, my
joint trial was
the
not
offences against
was not
later
started,
portion,
my lord,
later
because
portion,
unless cognizance take it.
Later part, my lord, the offences against Zakir Hussain Tapadar are also distinct offences, and the offences are triable by the Court of Learned CJM, Chief Judicial Magistrate, or other learned judicial magistrate of first class, as the offence against Zakir Hussain Tapadar is distinct from the offence of other three accused persons. So far as the question of date, time, and place of occurrence is concerned, we are of the opinion that separate trial is required. As such, split up the case record for accused Zakir Hussain Tapadar.
And then it was sent for
Zakir Hussain,
before Learned CJM.
yes, ma'am.
Yes. So that is the case. Okay. Basically, you are saying you are not at all related with the POCSO, admittedly,
No.
you're not there. But what about the other case? What do you want to submit?
My lord, in respect of other case, it is a complete false. I am not at all involved. My lord, in response to phone call, my lord, of the informant, I visited his house at around 9 p.m. It is true. I admit it honestly. And thereafter, I returned back in my own house in the same village, my lord. In the next day, I never visited in the school, nor used any slang language, nor I torn out the pages which was alleged against me, my lord. I am a headmaster of school, I have a responsibility. How can I turn out the pages of school admission register, my lord? And it is not within my custody, my lord. If it is the custody of the honorable court, can I turn out the pages, my lord?
That is the allegation.
That is the allegation, the main fact. I am the headmaster, and the informant is also headmaster of the school. Both are prudent and responsible citizens of the country. And on good faith, he approached, as per allegation, he approached that I want to see the admission register of 2013 and 14 with a view whether the victim girl is a minor or not. Because this victim girl was a student of this school, of the present informant. Now, he has, presuming, my lord, presuming he has allowed to show this, you kindly you see, no problem. Can a prudent man will turn out, and what will be the use for turnout page? Whether it can be produced before the court of law or whether it can be produced before any competent
No,
authority.
not to put it before the court of law, to make the victim as a major one. That is the issue.
No, my lord. Victim,
You
my lord,
will
victim
not
is a major
produce
one.
torn papers before the court. It's not the case.
No,
You are never going to produce those torn paper before the court.
yes,
It is the case that you want to suppress the
my lord.
age of the victim, or to produce audio. I mean, before the court, you want to produce that she was a major.
My lord,
That is the case.
my presuming for the time being, my lord.
My lord,
Suppose in the admission register name is there.
You may not be presumed. That is
will
different.
prove during trial, well,
The
otherwise.
birth certificate is there, my lord.
Prima
School
facie
admission
will be
register, other
confirmed.
school
How
admission
can
register
we
is
say
there.
why you gone for testing? Now we are not.
My lord, I know, I didn't went, my lord. He has invited me to come. On good faith, I visited there.
What
Because
was the previous
8 months before, my lord, the accident took place with my son. And in the FIR, my son is only involved. Thereafter, another 2 persons was found involved. And these 2 persons were also arrested, and they were remain in jail around 3 months. And subsequently, to take revenge against me, the subsequent FIR after 8 months, this was filed, my lord.
By the present petitioner. Why
By
will take revenge?
the present informant, my lord.
Yes, why he will take revenge against you?
My lord, I have no enmity with the headmaster of the
Yes,
present
why
informant.
he will take revenge against you?
My lord, in the village, I have some jealousy with I have some quarrel etc. with some other one. So to take revenge against me, they have filed this at the instance of the present informant. They have filed this FIR.
This is completely your case. Anyway, yes, Mr. Bottom.
Otherwise, my lord, he submitted that only to take revenge. On the otherwise, it is also submitted that the present informant is no way, my lord, connected with him. Otherwise, if the informant of the other affair, in the first affair, my lord, wants to take any revenge, my lord, then why the present informant Sri Joyprakash Sohan has lost this affair against the present? What is his, my lord, interest, my lord? Only because on that day you, my lord, went there to his residence, thereafter, my lord, asking him to produce the admission register, and you torn out those admission registers, my lord, for your own benefit. Those will come during trial, my lord. And his submission, whatever he has submitted, my lord, all these things he will have to prove during trial, my lord. Otherwise, prima facie from the contents of the FIR, those sections are attracted, my lord. Prima facie from the contents of the FIR, my lord. Otherwise, this is not a fit case for quashing of the FIR at this stage, my lord.
There is the other order at page. This is the 1610-2025 order is at page.
My lord, this is the case record of the case diary.
Case 45, my lord.
Page
45.
45, my lord.
They have, I mean, you are challenging the order of registration also, or what?
No, I am challenging the cognizance, my lord. Framing of charge.
The search framing order is there in the record, but
Yes.
my lord, here I have not found the search framing order.
No, you have also challenged the order of 1610.
Yes,
What
my
is
lord. At 2/8/2025.
No. What 1610 is, what is 16?
Unless my lord, if the charging.
No. What is 1610? 1610 is simpler case registration.
Yes, transmission of
Why
case.
transmission it is registered that?
But this is I annexed, my lord. It is I didn't challenge this, my lord.
No, but your cost title says in that way only. Prosecution witness 16, 16, 10, 20, and 20.
My lord, this
That
is
is
in
in the
respect of
admission.
segregated case record. Segregated. It was segregated from the original record.
So, because those sections are tribal by the learned CJM, so those
Then
transmitted
leave
to
us. So you are now basically want to against the impugn order dated 2/8/2025.
Yes, my lord.
And criminal proceeding, you are not against the criminal proceeding.
Regarding not my lord. Against the charge, my lord.
You are against the order of 2/8 only.
My lord, I am against the order of 2/8 and the entire criminal proceeding, my lord.
Where it is, entire criminal proceeding.
But my lord, prevention of shall be set aside into us, and on perusal of facts and evidence of hearing the party, your lordship would be pleased to make the rule absolute or shall pass any other order or orders as deemed fit and proper, my lord.
Yes, only the order dated 2/8.
You are only challenging the order dated 2/8/25.
Yes, my lord.
Criminal proceeding you have not challenged.
Entire proceeding automatically will come. My lord.
Automatic will later on, but you have not challenged. Whether it will come automatically or not has to be heard, Mr. I thoroughly done it. Mr. Report done it. It's an application.
Search framing order also not annexed.
Yes.
Also not.
PNSS, wherein the impugn order dated 2/8/2020 framing charge against the present petition under section 241 324 3 subsection 3 of the 238 PNSS related with section 3 of PDPP Act 1984 has been is submitted by Mr. Talukdar that initially one FIR was lodged against his son with the allegation of commission of penetrative sexual assault on a victim, and that accordingly the case has already been raised, charge sheet has been laid, and case is at this stage. After filing of the earlier FIR, another FIR was closed by one Jai Prakash Chauhan, the headmaster of Kopilipar number 2 LP school, with the allegation against the present petitioner that the day of the night of incident, he visited to his residence and also took school admission register from him, and thereafter asking for a glass of water, he turned the pages of the admission register, particularly for the year 2013 and 14, the students, and fled away from the place of the incident. On the next day, he also threatened with dire consequences, threatened the informant with dire consequences. Mr. Talukdar further submitted that in the earlier case, wherein his son was involved, his
PRC case number is there, my lord, in the para, my lord, pending disposal, fine.
para,
Yes.
PSC case number,
1953/2025, my lord. Page
you are
16.
against your son. Against your son.
No, no, my lord, against me.
Yes, PSC. The silo of PSC case number. No, not like your PSC. And in the said case, the case has already been charge sheeted against him as an additional charge sheet with the case filed against his son, which was registered under section 6 of the POCSO along with the other sections. He further submitted that the present petitioner is not at all involved in the alleged offense, or only involved in the alleged offense, And it is admitted fact that on the day of night of incident, receiving a phone call from the informant, he visited to his house, and thereafter, after having some talk, he returned back from his house. But thereafter, with some false and concocted allegations, the FIR has been lost against him, due to some previous grudge and enmity. Mr. Tarakdar further submitted that he is a respectable person of that locality and holding a post of a headmaster of another school with the same vicinity of the school of the informant. And due to some earlier grudge and the FIR has been lost with the false allegations. He further submitted that by its order dated 2/8/2025, the special judge Ujai has framed charge against the present petitioner under section under section 241, 324(3) and 238 BNS and read with section 3 of the section 3 of the PP Act, PP Act and PB Act. However, considering the charges to be a distinct offences that has been sent before the learned CGM for trial, and the Court of Learned CGM, by its order dated 16/10/2025, had registered the case against the present petition. Mr. Tarakdar further submitted that there is no material to frame charge against the present accused petitioner under this section of law, and he further submitted that there will be no use of prawning the papers from the admission register, as those also cannot be produced before the court or court. Thus, without any reason, he cannot prawn the pages of the admission register as alleged against him. Mr. Tarakdar accordingly submitted that it is a fit case wherein the case against the present petitioner may be set aside, entire criminal proceeding, including the charge sheet filed against the present petitioner under section 528 PNSS may be set aside by invoking power under section 528 PNSS. Next, Mr. Border, the learned additional PP submitted in this regard that admittedly the present petitioner is not involved in the earlier FR case laws against his son, wherein the allegation of penetrative sexual assault has been brought against his son and two others. But during that process, it has come to the light that the accused petitioner had visited to the house of the informant of the present case, where the victim of the earlier case was where he was studying, and for benefit or for some reasons, he torn the pages of the admission register pertaining to year 2013 and 14, pertaining to the year 2013 and 14.
2013-14.
14, for which the case is accordingly registered and charge sheeted. Mr. Bortakur submitted that there is no reason to file a false and concocted case against the present petitioner, wherein the informant has no connection with the petitioner or with the informant of the earlier case. It is a separate and distinct offense, and one for which initially it was brought for joint trial, but by the impugned order dated 2/8/2025, the case has been segregated after framing charge against the present petitioner and sent the case for trial before the learned city. Mr. Waterwood further submitted that there is distinct and allegations brought against the present petitioner wherein he damaged the public property by turning the pages of relevant pages of admission register for the year 2013-14, and considering all these aspects of the case, the IO filed charge sheet and finding prima facie case, the charge has already been framed against the present. Thus, there is no need of any interference, or the case is not at all is not liable to be set aside and quashed by invoking power under section 528 PLCs. Next paragraph. During the submission made by learned counsel for both sides, I have also perused this record. And it is seen that there is no material as to where no material to show that the case has lost only under some malafide intention to only to harass the present petitioner by the informant who is neither neither involved in the earlier case nor he is related to the informant of the earlier FIR. Informant of the earlier FIR lost against his son. Mere submission that the case has been lost only due to previous grudge is not at all sufficient to tell that not at all sufficient to quash the entire criminal proceeding against the present petition. In para 102 had the cases can held that the cases can be quashed under the following circumstances. The 102 para says agon the super. But here in the instant case, there is no material to held that the FIR has been lodged only with a previous grudge and enmity, rather from the submission made by learned additional PP and the materials in the case record. It is seen that the petitioner alleged to have torn the pages as the victim of the earlier case was studied in the Sage School. Sage School. So there may be some relevancy of turning the pages from the admission register pertaining to year 2013 and forward. So considering all these aspects of the case, this court of his opinion that it is not at all a fit case to set aside the implement order dated 2/8/2025 for framing charges against the present petitioner under section 22 so and so, and also not a fit case to quash the entire criminal proceeding pending against the present petitioner by invoking the power under section 528. Yes. The above observation, the present stands dismissed. Your petition stands dismissed. So,
For orders, item number 18.
Maybe there is a appeal mill against conviction, and I have filed an IA mill for bail. But at this mill, I am not pressing the IA. Only the bail may be hard mill and fixed. A date may be given mill for hearing.
Okay. Otherwise, you are appealing? Heard Mr. A. Rashid, the learned counsel for the petition. Oh, sorry, appellant, and also heard MSF Hussain, the learned amicus, appealing for the respondent number 2. And Mr. B. Sharma, the learned
LCR has come.
appealing on behalf of Mr. Submitted by Mr. Rashid that he, at this stage, is not going to press the present interlocutory application and accordingly free to list the matter for final hearing as the SJ has already been received. Next, in view of this, let the present I along be taken up together with criminal appeal number 87 of the 2024. You want a fixed date here?
My 23rd April, if possible, Miller.
Let us see. He's saying that 28 will be. It is the
My
hearing
lord.
date. Hearing date 28.
My lord.
Accordingly, let the matter be listed on 28th of April, 8th of April, so and so. And registry is hereby directed to list the matter for final hearing. Okay. Yes.
May I please to your honor? The senior counsel is in another court. Just pass the matter for a time being.
Time being, I cannot say because there are some hearing matters, so I cannot say at this stage. If some hearings
The
will be
senior
there at
counsel
2,
is
then
in
it may not
session
reach
court,
also.
Your honor.
Pardon?
The senior counsel is in session court.
না বুঝি পাইছো না সেশন কোড মানে টাইম দিতে এই টাইমিং করে দাও that people also বুঝি পায় না এটা but what I'm saying that if hearing starts then it may not reach also, that's what I'm saying, because at 2 I have a meeting also, most probably at 2 I may not even may not sit at 2 exactly because our meeting is there on 1:30, so maybe it's late for by 5-10 minutes only, that's all. Or whatever, but if hearing starts, then your matter may not reach, so better to take another date, I think. That's what I'm saying. Okay. Will be in order column only. We'll reach to it.
My lord, here in the last 2 occasions, my lord, it was fixed for hearing, my lord. Then again it has come for orders.
Why it has come? You highlighted here.
That's my kindly please last.
I or you are saying appeal?
In the I also it was fixed for hearing, my lord. Alia orders, my lord.
Oh, not. Obviously, appeal is in hearing.
My lord. Appeal, in the appeal also there is an order for hearing.
Your
Hearing with previous order.
in I have not find such kind of order that it will be taken up.
My lord.
But
My lord.
the
In the
appeal
I
is-
also order is there, my lord.
No, appeal is already for hearing only.
My lord.
Will it be okay for you? No, hearing on him. She may not be in a position to say that thing, so let it be on hearing column only. First of, we're giving a short date on 1st of April. Okay. Due to absence of the learned senior counsel, learned English counsel for the petition, matter could not be taken. List the matter on 1/4.
20. তুমি order is on
Yes, one I is there.
Lordship, actually the main appeal which is against conviction, that was not admitted, Lordship. So my prayer is before your Lordship is that matter may come for admission. On that day, we will press IA also. For that is for suspension of sentence, Lordship. Appeal has not been admitted yet. Notice was only issued and amicus curiae was appointed.
You are the amicus?
My lord,
And
ex counsel is N. Mahajan, my lord. He's on his legs at another court, my lord. It will take some time, my lord.
No,
a date may be fixed
My
for
lord,
admission of.
Kindly a short date may be fixed only for
why
2 days.
why are you insisting for short date? You are for amicus only. Then
They have not appeared, so this honorable court appointed an amicus curiae lordship. Appeal may come for admission lordship. Then only the question of suspension of sentence will come. Lordship.
you are MS
S.
S.
Kanungo.
Kanungo, Mr. I'm sorry, MSM S. Kanungo, the learned counsel for the applicant appellant. And also here you are Mr.
N.K. Fukan, my lord, appearing on
Also
behalf
heard
of
Mr.
N.
K.
Mahajan.
Puka, appearing on behalf of Mr. N. Mahajan, the learned amicus for the respondent number 2, and also Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. It is submitted by MS Kanungo that the appeal is not yet admitted in this case, and accordingly she submitted that the matter may be come up in the admission hearing column when the IMA also be heard accordingly. In view of this, the registry is hereby directed to list the matter in admission column. You want any
After
fixed date?
Bihu lordship.
After Bihu. Fixed date will be Pagala. 24th of April.
Deeply
It
obliged.
will not affect you. I'm just saying you.
Yes,
you are
ma'am.
just amicus.
He is in jail lordship.
Because
The
he is in
petitioner
jail.
is
It
in
is
jail.
the case of their urgency, not yours.
Yes, my lord, yes. Deeply obliged, lordship.
Deeply.
I think. Lordship, as per office note, lordship service is awaited. So this matter in the first week of April, lord.
Service is still awaited. Heard Mr. A.T. Sarkar, the learned counsel for the petition. As per, and also heard Mr. Vishnu, the learned additional PP appearing on state respondent. As per office note dated 20/03/2026. The service is still awaited for the respondent. Let the scan copy we have received here? No. Scan copy to scan copy, however, the scan copy of the TCR has already been received. Let the service be service for the respondent number 2 be awaited till next date of listing. You are saying first week of April. First week of April, only 6, 7, 8 is there, na? Only 6, 7, 8 is there. 9 we are listing. 9 may be a holiday only. Declared or declared, sorry, not maybe, it's a declared holiday only.
8 on 8, lordship.
8 cannot. Immediately after vacation, we'll do at 20 on 20, 20, listing it on 2. "22, you have already appeared.
Yes.
The name is not there. That's why I thought that
I'm filing Ukalat number today.
you have filed Bokalatnama today.
Let the matter give him the admission, my lord, on the next.
Then it may come with any admission call.
My lord, after vacation, my lord.
On 22nd, Dada, hearing?
22nd to 23rd, my lord, any day.
Hard.
Heard Mr. B. Datta, the learned senior advocate, assisted by Mr. S. Deka, the learned counsel for the petition. Also heard Mr. You are Upadhyay, na?
Upadhyay.
NN Upadhyay, the learned counsel appearing for the respondent, right, respondent number. And he submitted that he had filed his Bokalatnama today, and accordingly needs some time. You want to file any objection here or
I'm filing.
verbal submission?
Law point.
Criminal petition, my lord.
Only law point.
Oh, yes,
Oh.
criminal petition.
Submitted that he needs some time to make his submission. In view of this, let the matter be accordingly listed in the admission column. The rest you will, yes.
Twen-
Will be
twen-
confident 22
23, your lordship.
23.
Yes.
Right.
Okay,
No, no.
23.
Interim to continue.
Interim listing. 23 for corridor, interim be continued till name date of listing.
May I take one indulgence, my lord, or with the permission? On 20, item number 28, my lord.
Hearing.
My learned friend of the other side, my lord, requested for an accommodation. He is here. So he's to his
28.
his daughter is now in champion in that badminton. He is just informed in the national cadet. So we
But why
congratulate.
you are still here?
No, she is in the deaf category, Lord.
So she will come. So she will go to the airport for receipt.
No, it's
Oh.
not like that.
Oh.
Only to, I mean, like, ensure her preservation. And to go. Otherwise, that's not an excuse.
Anyways. You're for the respondent.
Yeah.
Yes.
Sole
Total. Item number 28.
Yes. Heard Mr. B. Datta, the learned senior advocate, assisted by Mr. S. Dekar, the learned counsel for the petition, and also heard you are Mr. Dekar.
Yes, yes.
P.S. Dekar, the learned counsels for the sole respondent. And at the request made by learned counsel for both the sides, let the matter is adjourned. Any preferable date for you?
21st to 23rd, any day. 21st,
21st can be?
21st, 22nd.
21st. 21st.
My lord.
Lordship.
Grateful, my lord.
So these days you are here.
Yes. Interim, my lord, maybe.
Yes, okay. Interim be continued till next year.
Grateful, my lord.
All right.
Yes.
Lordship, as per office note 23-26, the scan copy of PCR not yet received, Lordship. And service upon the respondent 20 is awaited, but in the CI system,
Oh, she is
Yeah.
appearing for?
For respondent number 2 and 3, we have
2 and
filed our wakalatnama, Lordship. 2 and 3.
and then service is complete, Lordship. Only TCR not yet received.
Only this year not received.
TCR
But,
not received. As
2
per
and
office-
3 already.
Already,
they have done.
respondents.
You are also appearing for someone?
4 and 5.
2, 3, 4 and 5.
One is the state.
One is state.
Okay.
So service is completed already.
Lordship, service complete.
Heard Mr. N.J. Gogoi, the learned counsel for the petitioner. Also heard MS M.K. Brown. No, also heard Mr. B. Sharma, the learned additional PP appearing for the state respondent. And MS M.K. Brown. You are not the amicus here, you are
No,
appointed.
yes, Your Lordship. I, along with Mr. Javed Ali Hassan, we both will be appearing for respondent number 2 and 3. We have filed.
Yes, Lordship.
It's okay. And also heard MS M.K. Brown, the learned counsel appearing for the respondent number 2 and 3, and it is submitted that you have already filed your wakalatnama?
Yes, Your
You
Lordship.
have already filed their wakalatnama. Also heard Mr. Your S.A. Ahmed. F.A., not S.A. Acha. F.A. Ahmed, learning counsel appearing for the respondent number 4 and 5. Thus, it isn't that the service is already completed. However, from the office note, it reveals that the TCR is still awaited. A registry is hereby directed to issue reminder. List the matter accordingly when it 27th of April will do.
Lordship. The case is in the appearance still, Lordship, but there is no state, so Lordship, 27 is okay.
27th.
Obliged.
Huh?
Yeah, Peter Lordship, regarding to item number 24, Miller, I'm paying for some accommodation to them, Miller. Yes. After.
You are for the appellant.
Yes.
Okay, you are for the respondent. I
Yes, my lord, respondent number 2.
with the consent of the other side. The learned counsel appearing for the appellant, paid for short accommodation. the prayer out. Let the matter be listed. 28th of April will do. It's a hearing day.
Much obliged, my lord.
P. Sharma Dilan, additional PP appearing on state respondent. However, in absence of the counsel for the respondent, the matter could not be taken up. And listed. After vacation we'll do, or you want a fixed date here? You want any fixed date or after vacation? we'll
After
do?
vacation.
After vacation. List the matter accordingly for hearing immediately after vacation. Immediately after vacation. Due vacation.
Obliged.
So one Ayu Chaudhary. Ayu Chaudhary, you are pressing the IA or criminal appeal, because criminal appeal is also for hearing.
Lordship,
So we can hear the matter.
hear the matter that.
Now, but the question is that where is the Ayu Chaudhary? Where is Ayu Chaudhary?
Lord,
Mostly he is appearing for the respondent number 2.
amicus, madam.
Amicus.
Yes.
Can he be informed?
Fine.
Open there. সময় নাই কেন? He gone, I think, the Muslim. Maybe for Eid and all, he may. I don't know whether he is coming now.
He is in the court, my lord.
Court. Okay,
Only in which court, and just he has went for.
Cases of 25, na?
25. He is in jail, my lord.
Since when he is in jail?
During trial, he is in jail for about 84 days, and after judgment, my lord, from 30/12/2024.
30/12/2024.
2024.
For more than 1 year.
1.5 year in total, my lord, and conviction is for 5 years, my lord,
5 years.
under section 10 of the POCSO Act, my lord.
Yes, it is a 10 of 10 POCSO. So, and I have gone through the record yesterday. It's very, the allegation is very, I mean,
Where in fact, my lord, already on the basis of the evidence of my or 2 PM or 11.
2, 3.
It is not a material.
yes, I have not gone through the entire record, but the allegation is very
Allegation is serious, my lord.
serious.
Only, my lord, my submission is that, my lord, probability, because, my lord, the victim says, all the persons examined says, my lord, there are only 2 rooms, my lord. In one room, there are 3 classes. In another room, there are 2 classes, my lord. And there is no separate office room, my lord. There are teachers, students, everybody is there, and the alleged incident took place during the school hours. Whether it is possible, my submission is that the possibility, my lord, is preponderance of probability, because, my lord,
Let us hear the entire matter.
Yes.
That's why Mr. Ayu Chaudhary is not there, so
Yes, my lord.
I don't know. Can it be listed on the next hearing date here? First to 30 years. 31st. 31st will do, otherwise.
My lord.
This is a hearing day.
My lord.
Yes, you are appearing for Mr. Chaudhary. So where is he? Is there any matter is there going on or what? Then we don't have any other matters such, so we cannot wait for. Otherwise, it could have been time being matter. But at present too may not be possible. So, okay then, 31st. We are listing it on 31st. 31st. Due to absence of the learned amicus, who is appearing, respond number, the matter could not be taken. And list the matter according on the 31st, we act is still. Okay. We're listing it on 30th.
Obliged.
Yes, 29. You are for the petitioner. You are for the respondent. Respond number 2. Status for 1.
That is there.
Ready? Okay.
Lordship, this is for passing, Lordship. There
This
is
is for washing.
Yes, Lordship. First, I take your Lordship to page number 29. This is in vernacular, Lordship. I read the vernacular portion. This is the FIR. It has been lodged by the petitioner.
Case 29 is the FIR.
Yes, Lordship. On the date of incident. সন্মানপূৰ্ব বিনীত নিবেদন এই যে মই তেজপুৰ চহৰৰ প্ৰথম অংশৰ উৎকানগৰৰ ডাকনং নাম্বাৰ 1209 নতুন আৰু বৰ্তমান 870 নতুনত 1 কথা 11 চামাতি শ্ৰী ফণীন্দ্ৰ কুমাৰ বৰাৰ পৰা ক্ৰয় কৰিছিলোঁ। যোৱা ইংৰাজী 27 নৱেম্বৰ 2024 তাৰিখে সম্পূৰ্ণ নীতি নিয়মৰ মাজেৰে মাটিখিনি ক্ৰয় কৰিছিলোঁ। মাটিখিনি বটোৱাৰা হৈ নতুন দাগ আৰু পট্টা নম্বৰৰ ওপৰত দিয়া হৈছে। ক্ৰয় কৰা মাটিখিনি জমাবন্দী খাজানা ৰচিদ ট্ৰেন্সফাৰ আৰু অন্যান্য প্ৰয়োজনীয় নথিপত্ৰ সকলো মোৰ নামতে আছে। বেচা কিনাত বেচোতাৰ পুত্ৰ
Okay. Yes.
বেচা কিনাত বেচোতাৰ পুত্ৰ শ্ৰী অনুপম বৰা সাক্ষী হিচাপে আছিল। ছেকেণ্ড পেৰা। কিন্তু আজি ইংৰাজী 3-3-2025 তাৰিখে ইজ ডেট ইজ ইম্পৰ্টেণ্ট হৈছে। উক্ত মাটিৰ ওপৰত ঘৰ বনোৱাৰ যোজা কৰাত মাটিৰ পূৰ্বৰ গৰাকী ফণীন্দ্ৰ কুমাৰ বৰা আৰু তেওঁৰ ছোৱালীয়ে উক্ত মাটিত মোক ঘৰ বনোৱাত বাধা প্ৰদান কৰি মোক গালি গালাজ তথা প্ৰাণে মৰাৰ ভাবুকি দি খেদি পঠিয়ায়। গতিকে পদকীয়াজনে মোক উক্ত মাটিখিনি সম্পূৰ্ণ নীতিগতভাৱে বিক্ৰী দিয়াৰ পাছতো মোক উক্ত মাটিত ঘৰ বনোৱাত বাধা প্ৰদান কৰি ষড়যন্ত্ৰমূলকভাৱে মোৰ লগত ঠগ প্ৰবঞ্চনা কৰে। গতিকে পদকীয়াজনৰ বিৰুদ্ধে আইনগত ব্যৱস্থা গ্ৰহণ কৰি
I mean, land from Phanindra only.
Yes. He purchased land from
And as per the allegation that Phanindra
and his daughter prevented him from constructing house. Now this is the affair from the petitioner's side. After 1 day of the incident, the informant waited for 1 day in this case, whose affair I want to get first, Lordship. So that is at page 22.
Earlier FIR was lost by you also.
Yes, sir. After 1 day, after thinking about what to do, they have to retaliate the matter. They come before the police. বিষয় এজাহাৰকাৰী ফণীন্দ্ৰ কুমাৰ বৰা মহোদয়, এজাহাৰকাৰীৰ নিবেদন এই যে এজাহাৰকাৰী সুস্থ অৱস্থাতে এজাহাৰকাৰীৰ জীয়ৰীক 1 কথা 11 লেচা মাটি দান দিয়ে আৰু জীয়ৰীয়ে সময় আৰু সুবিধামতে ঘৰ বনোৱাৰ বাবে ৰাখি থৈছিল। এজাহাৰকাৰীয়ে জীয়ৰীক দিয়া মাটি এজাহাৰকাৰীৰ পুত্ৰ শ্ৰীমান অনুপম বৰাই এজাহাৰকাৰীৰ পৰা অতি চতুৰ ও কৌশলগতভাৱে বেলেগ মাটি বিক্ৰী কৰিব বুলি কৈ এজাহাৰকাৰীৰ পৰা চহী আনি চক্ৰ বিষয়া কাৰ্যালয়ৰ মণ্ডলে শ্ৰী প্ৰবীণ দেৱনাথৰ পৰামৰ্শ আৰু চক্ৰান্তত পৰি মাটি বেচা কিনা অনুমতি লৈ জামুগুৰি নিবাসী শ্ৰী ভাৰ্গৱজ্যোতি নাথক অধিক মূল্যলৈ বিক্ৰী কৰে। যোৱাকালি 3-3-25 তাৰিখে পুৱা 10:30 বজাত শ্ৰী ভাৰ্গৱজ্যোতি নাথে লগত কেইজনমান বনুৱাসহ ঘৰ বনোৱা সামগ্ৰী লৈ অনাধিকাৰ মাটিত প্ৰৱেশ কৰি ফিটা মাৰি মাপ লোৱাত এজাহাৰকাৰী আৰু জীয়ৰীয়ে ভদ্ৰভাৱে তেওঁক সোধাত তেওঁ অতি উগ্ৰ হৈ অশ্লীল ভাষাৰে গালি পাৰি বাধা দিয়ে আৰু অপমান আৰু প্ৰাণে মৰাৰ ভাবুকি দিয়াত এজাহাৰকাৰীৰ জীয়ৰীয়ে মাত মতাত তেওঁকো ঠেলাই হেঁচা কৰি গাৰ কাপোৰত ধৰি পিছফালৰ পৰা গোটা মাৰি দি অতি উগ্ৰ হৈ লগত অনা হাথিয়াৰ উলিয়াই চোচা মাৰি আহাত এজাহাৰকাৰী আৰু জীয়ৰীয়ে কোনো প্ৰতিবাদ নকৰি আইনৰ আশ্ৰয় লোৱাত ব্যৱস্থা কৰি এই এজাহাৰ
The case lost by you has already been charged.
Yes, okay.
His case is charged or your case is?
No, my lord, 148
148.
Yes. 148. Present affair is 149.
The case in under which this quashing is paid for is 148 or 149?
149.
149.
Yes.
No, not 149. Who are you? You
I am informant in 148.
Phanindra.
Yes, no, I am Bhargavjyoti. I am Bhargavjyoti. I purchased the land by paying more than 60 lakhs. And when I wanted to construct my house,
No. Earlier, your case was lost subsequently.
no, my case was lost earlier. To retaliate
You
my
lost
case, they have come.
148.
Yes.
You lost 148.
Yes,
And they lost 149.
they lost 149.
Which has been charged?
148 is certified. My case has been certified.
148. Lost by you.
Yes.
22 is lost by you, na? No, no.
148 lost by. Page 29.
Sorry. 20.
9. Page.
Your name is Bhargav Jyoti.
Bhargav Jyotinar.
Bhargav Jyoti. Acha. 29 FI is charged.
Certified.
Already charged.
Yes. Yeah, it is from their information. I do not have the information whether it has been certified
No,
or not.
charged it is scan copy is there only.
Okay.
And FIR 22 is FIR lost against you.
Against me. That was one day after the LS incident.
So that is still pending.
That is still pending.
The FIR lost against you is still pending.
Yes, sir. Oh,
So 29 is the FIR lost against you, na?
yes, sir. 29 is the FIR lost by me, Lord.
22 is the FIR lost against you.
Yes, sir.
So FIR lost by you, that is on 29, has already been charged.
Yes.
Then your under which you are appearing, it is still under investigation.
Yes.
Okay. Yes. Then.
Under
149 is under investigation.
The case which is he is appearing, it is case diary.
Lordship, a civil case has already been filed because since this is a matter relating to civil matter, so
who filed the lost the civil?
the civil one filed by the informant of that 149 subsequent. The original owner.
Informant of the present case had instituted
Yes,
a civil suit.
Yes. So in that case, Lordship, I have filed my written statement also. The contents of the title I want to read, Lordship. It is at page 40. It contents start from page 40.
40 is your WS.
No, 40 is the title suit.
40.
40.
Yes.
That the plaintiff and the defendant are the permanent resident of the above mentioned locality, which is within the jurisdiction of this court. That the defendant number 2 is the son of the plaintiff hearing, and the defendant number 3 is the last member of the circle office dashboard. That the plaintiff is the owner, title holder, and possessor of the land measuring 1/11 lessa covered by tag number 804 PP number 486 situated dashboard on passport Moza Koirapot PS dashboard district unit Assam, which is more fully described schedule A. The third para is missing. Yes, internal base 5. Borosa Mohanto, we are interest performed in the title suit. The performed number 2, namely Borosa Mohanto, married to Girish Mohanto, but as the marriage between the performed 2 and her husband was doomed marriage, so the plaintiff brought his daughter to her parental home to live with her father. That is the plaintiff herein. And subsequently, the husband of the performed number 2 died in the year 2024. Then, except the suit schedule A land, the plaintiff had several posts of land differently located in Tezpur. That as the performed number 2 is a destitute woman, so considering the future of the daughter, the plaintiff had decided to give the suit schedule A land to the daughter. That is the performed number 2 herein. And above decision of the plaintiff was also expressed before his two sons, the defendant number 2 and performed defendant number 1 herein. That on 3/3/25, the performed defendant number 2 noticed that the defendant number 1 along with some daily wage earners entered into the suit land. Suit schedule A land started to measure the land for construction. That when the performer defendant number 2 asked the defendant number 1 why the defendant number 1 entered into the schedule A land, the defendant number 1 started to abuse the performer defendant number 2 with some obscene language and also physically assaulted the performer defendant number 2 therein. That all inquiry of the plaintiff came to know that his name is Anupam Bora, that is the defendant number 2 herein, fraudulently obtained the signature, and with the help of the defendant number 3 therein, who was love model of sold the suit schedule A land to the defendant number 1 herein. That after coming to know about the misdeed of the part of the defendant, the plaintiff lodged an azhar against the defendant herein, which was registered as Tezpur PS case number
149 under section 12 that plaintiff has no reason to sell the suit schedule A land which is kept for his daughter's future. That the defendant number 2 in the initial part of the year 2024 requested the plaintiff to sell part of the schedule part of the land situated in the lot number 4 of first part of Tesco Town as he has some financial urgency. That considering the financial urgency of the defendant number 2, the plaintiff agreed to accept the proposal of defendant number 2. The defendant number 2 took some signature of the plaintiff for sale permission, but the plaintiff never appeared before any authority for sale permission of the land. That the defendant number 2 conveniently, which connivance which defendant number 3 took sale permission of the suit schedule A land of the land proposed to be sold. On 27/11/24, defendant number 2 took the plaintiff, who is almost 80 years old, with informing his other children to the sub-register office without informing his other children to the sub-register office to execute the sale deed. That the plaintiff has no reason to disbelieve his son, that is defendant number 2, herein. As per the instruction of the defendant number 2, the plaintiff appeared before the office of the senior sub-register and executed the sale deed being document number so and so, that is so and so, in favor of the defendant number 1 herein, and is more fully describing the suit schedule B below. That in the sale deed, the defendant number 2 put his signature as witness number 1. That during the execution of the process, the plaintiff never believed that the defendant fraudulently executed the sale deed in respect of the suit schedule A land instead of piece of land proposed to be sold. That the performer number 2 noticed the defendant number 1 in the suit schedule A land, and then only for the first time the plaintiff came to know that the defendant number 2 with connivance with defendant number 3 fraudulently sold the suit schedule A land to the defendant number 1. The plaintiff never put his signature in any paper for sale permission in respect of the suit schedule A land, and never appeared before any authority for sale permission of the suit schedule A land. The signature obtained by in the sale deed being document number so and so was taken. This line is missing. The fact that defendant number 2, with connivance of the defendant number 3, tried to sell the suit schedule A land instead of the piece of land proposed to be sold. The plaintiff would never put his signature on
The question is that uh, it is the case of the plaintiff or the informant that he took his own son Anupam or whatever.
Yes, Lord.
Took the signatures of his father in some papers, stating that there is another plot of land which are going to be sold. But admittedly, he put the signatures. Signature is not disputed.
Yes, Lord. He admitted the signature is good. He told that his son has some financial difficulty at Pira 6, and therefore he allowed to sell in the land. Thirdly, the plaintiff has not stated anywhere which plot of land he actually wanted to sell. There is no other land of the plaintiff. He has not been able to say that I want to sell this plot of land, but my son sold.
Some land they put down itself where it was proposed to sell.
Yes, Lordship. That was not mentioned by the plaintiff. There was no land. So these are the things, Lordship. That's subsequently manifested. Yes, Lordship. And what happened, Lordship, most interestingly, the sale permission was obtained by giving the old DUG numbers. But in the meantime, new DUG numbers came. They paid regular land revenue in the new DUG number and pata number. But for that sale agreement, old DUG number and pata number was given deliberately. Thereafter, when the permission was applied, it was found that the DUG number and pata number was not matching. Therefore, that sale permission was earlier rejected. Thereafter, they gave the new number, and on that the sale permission was obtained and sale deed was registered. The person physically appeared before the sub-register plaintiff on 2 occasions for registering the agreement also and for sale deed registration. So after all this, it is a practice that the sub-register always inquires that whether you have received the money, whether you are going to sell, is there any question? This part is always there. And now he is saying that he did not want to sell this land. It is a purely civil matter, Lordship. The person, the FIR is a afterthought, Lordship. Now, I want to come to my written statement, Lord.
Tell us, this civil suit is instituted after lodging of the FIR or prior to?
After lodging of the FIR.
Lordship may come to page 53.
53.
I have stated everything in my written statement.
Yes.
Paragraph 8. That it is humbly submitted that the statement made in paragraph 5 and 6 are exclusively denied by the defendant number 1 to be wrong. The truth revolved around the fact is that defendant number 1 was looking for purchasing some suitable land at Tezpur town, being the public servant of the by possession. Now, also I want to just interrupt here. The plaintiff has also not denied of receiving rupees 60 lakhs for sale of the land. Apparently, from some friends and friends of friends, defendant number 1 learned that Sri Anupam Bora, being defendant number 2 of the instance, being the son of the plaintiff, had published a public advertisement in the month of February 24 in OLX social media platform that his father, Sri Phanindra Kumar Bora, would sell a scheduled plot of land, more specifically in the scheduled suit land in question, and the sale consideration was fixed at rupees 68 lakhs. That when defendant number 1 came across the advertisement, and accordingly he contacted the owner, thereby defendant number 1 met Sri Anupam Bora, that is defendant number 2, and his father, Sri Phanindra Kumar Bora, that is the plaintiff. Both of them took defendant number 1 to show him the plot of scheduled land. The plaintiff showed defendant number 1 all the documents pertaining to the land, which defendant number 1 further checked in Gauhati.com under Government of Assam website, wherein he found the record to be genuine. Being satisfied with the authenticity of the land records and a suitable plot of land to be purchased, and therefore on 27/3/24, both the parties, that is the plaintiff and the defendant number 1, entered into an agreement for sale by number so and so, that is so and so, serial number so and so, that is so and so, and wherein the plaintiff agreed to sell the scheduled plot of land measuring 1/11 lessa covered by DAG number 607 of periodic patta number 345 situated at Tezpur town, first part, PO and PS Tezpur in the district of Sonitpur, Assam, along with his specific boundaries, specifically detailing schedule below, by accepting an advance sale consideration amounting to rupees 28 lakhs only, while the remaining balance sale consideration would be borne by the at the time of execution and registration of the sale deed in presence of the witnesses. On the same day that itself, defendant number 1 had advanced the plaintiff rupees 28 lakhs in cash out of the total sale consideration amounting to rupees 60 lakhs only, to which the plaintiff duly acknowledged by providing money receipt to the defendant number 1. Everything was conducted in the presence of Sri Anupam Bora, being defendant number 2, and proper defendant number 2, Srimati Borsa Mohanto, being the daughter of the plaintiff. The plaintiff, being the retired assistant commandant of Indian Defence Force, is highly literate person who went through the agreement three or more times before signing it. Thereafter, the plaintiff himself, as permission was completely the owner's part, had applied for the land sale permission, which was generated by NOC number so. However, after some days, the plaintiff approached the defendant number 1 and told him that there occurred some problem while obtaining land sale permission, as Ratmondal objected since DAG and patta number were whole. After some days, the plaintiff collected the records collected from the DC office Tezpur and told defendant number 1 that the land was already partitioned many years back, which he had forgotten, from DAG number 607 to 804 and PP number 345 and 486 in the year 2008-2009. As per the order of the circle officer Tezpur dated so and so, as per the plaintiff, the circle officer had requested him to freshly apply the land sale permission, and therefore he again collected the signature of defendant number 1 while signing the new land sale permission application. Defendant number 1 saw a khazana receipt of the foot land submitted by the plaintiff, the copy of which was later collected from the circle office Tezpur. The defendant number 1, through some reliable sources, found that the plaintiff was paying revenue taxes of the scheduled land against the new DAG patta number previously, but the plaintiff willfully made agreement with defendant number 1 against full DAG number 607 and patta number 345, which proves that the plaintiff was totally aware knew everything about the partition of the new DAG and patta number and from the old ones. After that, the new application number for land sale permission, where the area of land and boundaries were exactly the same as mentioned in the agreement that so and so, right? NOC number so and so generated on 28/10/2024. The NOC number so and so dated 28/10/24. The district commissioner Sonitpur at Tezpur gave permission to sell the suit land. That in the permission, the government valued the scheduled land has been as rupees 18,60,000. Interestingly, the plaintiff told defendant number 1 that he is suffering from severe nerve problem, and a hefty amount of rupees 9,71,500 only had been expensed by his son, being defendant number 2, and daughter-in-law, namely Srimati Jirisri Bora, in his retirement. Further, the plaintiff told defendant number 1 that the
intensity of the disease has been increasing and therefore he cannot go to senior sub-register office just for giving the signature. Even the plaintiff applied for permission to get the registration works in his residence, requesting him to allow the register to be registered a seat suit plan at his own residence, to which the defendant number 1 strongly opposed and stated that he shall wait till the plaintiff regains his health and express his willingness to take registration at the suit plan. Registration of the suit plan at senior sub-register office Sonitpur at Tezpur and not at the residence of the plaintiff. On 27/11/2024, both the plaintiff and defendant number 1 entered into the deed of sale dated 20/11/24, wherein the plaintiff fixed the sale consideration amount of rupees 18,60,000 instead of actual amount of rupees 68 lakhs. On being questioned about the same, he told that in order to escape tax evasion, the deed of sale dated 27/11/24 was duly executed in presence of the witnesses that defendant number 1 paid the remaining balance amount of rupees 40 lakhs, only by rupees 30 lakhs 28,500 only in case, and 526 by SBI check number 45336 for an amount of rupees 5 lakhs only to Zero Street Bora, wife of defendant number 2, and check number 45338 for an amount of rupees 4,71,000 dated 29/11/24, which reflects from the mini statement submitted here to the defendant number 2, naming which was duly acknowledged by both the parties in presence of the witnesses. Hence, defendant number 1 has made full and final payment of the sale consideration amount of rupees 68 lakhs only to the plaintiff and his family members in their presence and full knowledge from the very beginning. Then the plaintiff had handed over the suit land to defendant number 1, which has already bounded by boundary wall in two sides of his land by Sri Vipul Kakoti and Sri Sandan Soikiat. In other two sides, defendant number 1 had constructed concrete pillar that hide front and back side only. That hide application number 19/12/24 to NOC for construction has also applied by the plaintiff. By the plaintiff was accorded together with the condition mentioned in the overlay. Thereby the plaintiff as vendor wrote hereby transfer, confessal and assign absolutely unto defendant number 1 all the piece and parcel of the suit land, and also the defendant number 1 had taken over the physical possession of the suit land. The details which have been annexed here is under that. Thereafter, defendant number 1 applied for partition of the land by the application number so and so, and the partition was granted.
So in that title suit, what was their prayer?
Title suit was,
Their prayer?
I go to the prayer for time. Cancellation of the sale.
Cancellation of this.
Declaration of right title interest of the plaintiff. Then declaration of sale deed being so and so, that is so and so is illegal, and cancellation of sale deed being document number so and so, that is so and so, executed and registered between plaintiff and defendant number 1. For the mutation entry date number so and so and the partition of defendant number 1 is illegal, and consequent relief of cancellation of the mutation entry. Then permanent injunction. These are the prayer. Lordship, since civil suit is there, Lordship, it is an absolutely civil matter. The FIR was lost by the plaintiff is afterthought. Therefore, the FIR may be passed out, since the remedy is available to the informant in the civil. Lordship, let them give the reply. I want to submit response to their reply.
FIR was lost by the FIR was lost by the respondent number 2 against 3 persons. Accused number 1 is Anupam Bora, his son. Accused number 2 is the petitioner herein, Dokjyoti Pratap. And accused number 3 is Probin Devna. He was the Mondal. Basic allegation is that in the text that his son will sold some other land. His son Anupam Bora and Probin Devna in an conspiracy stole this land. The present petition here. So the FIR is a case of thieving, and this case has been filed for crossing of the FIR by only the petitioner, that is Bhargav Jyotin. And respondent number 2 is an 80-year-old person. In the FIR as well as in the other documents also, in the plaint also, it is written he is 80-year-old person. So by believing his son that he will sell some another land, he has sold this plot of land to this to the petitioner. And one more thing, in the
agreement for sale, which is at page 62. Page 62. Page 62 agreement for sale start. Here, the sale consideration has been shown as 68 lakhs. And in the sale deed, it has been shown as 18 lakhs 60,000. And the way the petitioner has paid the amount, also maybe look into 60. He said that he has paid 68 lakhs rupees to the respondent number 2. So out of which 28 lakhs paid on the date of agreement. 30 lakhs and 30 lakhs 28,500 paid on the date of sale deed. And more than 58 lakhs has been paid by way of cash, and he is a public servant. So he has paid 58 lakhs 28,500 by way of cash to an 80-year-old person, and rest of the amount, almost 10 lakhs. 10 lakhs has been paid. Out of 10 lakhs, 5 lakhs has been paid to the wife of the accused number 1 of the FIR. And 4,71,500 has been paid to the accused number 1. And another thing, in the page 68, page 68, page 68 is the pre-registration summary. It is nowadays it is mandatory. If we when we go for any registration of a document, we have to fill up all the details. The page 68 is mandatory that before registration we have to enter all the details at the website of the government of Assam. Here the first party, Ponindra Kumar Bora, his name has been shown, and the mobile number which is mentioned 9085 695800. As per my instruction, this is the number of the accused number 1 of the FIR, Anupam Bora. This number doesn't belong to the respondent number 2. And this is the pre-registration summary of the agreement for sale. And now if you go to the pre-registration summary of the sale deed, which is at page 78, so sorry, 76. Page 76. Yes, this is the pre-registration summary of the sale deed, the final sale deed. Here, seller and buyer, both phone numbers are different. Both phone numbers are same.
No.
6900893452. And the buyer phone number 6900459452. So these phone numbers doesn't belong to my respondent number 2. In case, and another important thing, he has mentioned that the DAG number and patta number has been changed, and the respondent number 2 did not inform him at the time of execution of the agreement for sale. Now, if we go by his document, page 53, page 53, page 53, it's paragraph 8. Here he has written that he found the land sale advertisement in an OLX social media. Ninth line. So published a public advertisement in the month of February 2012-24 in OLX social media platform that his father so and so would sell. So admittedly, the son put an advertisement in a social media platform OLX that they are going, his father is going to sell. So whether his father is going to sell it or not. So another important thing regarding the change of tag number and patta number, fifth line from bottom. The plaintiff showed defendant number 1 all documents pertaining to land, which the defendant number 1 further checked in Dhoritri.com under Government of Assam website, wherein he found the records to be genuine. So he has stated that before execution of the sale deed, the agreement for sale, all the documents were handed over to him. He has gone through the document. Even he has gone through the documents in the website of the Government of Assam, Dhoritri. And later on, and in paragraph 54, he has mentioned that lot number objected since the tag number, patta number were old. After some days, plaintiff collected the records from the DC office of the Tezpur and told the defendant number 1 that land was already partitioned many years back. Plaintiff collected the records from the DC office. It's an 80-year-old person. He went to DC office and collected all these documents. And in fact, the tag number and patta number against which the sale deed has been registered and the agreement for sale has been registered are completely different. And that is a matter of trial only. In the case of investigation, in case of trial only, it can be ascertained whether whether those are same land or not. So in fact, in the FIR also, the FIR lost by the petitioner, tag number and patta number are different. Page 29. He has mentioned tag number in paragraph in page 29. সন্মানপূৰ্বক বিন্ত নিবেদন এই যে তেজপুৰ চহৰৰ প্ৰথম অংশৰ উষানগৰৰ ডাক নাম্বাৰ ইমান আৰু পত্তা নাম্বাৰ ইমান নতুন এক কথা মাতি he has not mentioned the old tag number, neither the tag number mentioned in the agreement for sale nor the tag number mentioned in the agreement in the sale deed. So there are 3 tag numbers in 3 different documents. There are 3 tag numbers, and now he is saying that so this tag number and patta number has been changed due to this. So whether those are correct or not, those are matter of trial only. And interestingly, this FIR has been lost by a father against his own son. So this accused number 1, Anupam Bora, in connivance with this Lakmandal, sold this land to Bhargav Jyoti Nath, the petitioner, behind the back of the petitioner, and in this way he has cheated his cheated his father, and there is clear criminal breach of trust. In fact, the respondent number 2 has clearly mentioned in his claim that he has not received any amount. Page 44. Page 44, paragraph 8, last part. The plaintiff also never received any consideration amount in respect of sale of land from the defendant number 1 in any manner whatsoever. So whether the land has been sold by the respondent number 2, whether the land he has obtained the sale deed genuinely, and whether there is any connivance with the revenue officials or by this his son Anupam Bora, is all the matter of trial, on the matter of investigation. And in the FIR, we have alleged that this part of land was marked
mark for his daughter, and it has clearly been mentioned. এজাহাৰকাৰীয়ে জীয়েকক দিয়া মাটি এজাহাৰকাৰীৰ পুত্ৰ শ্ৰীমান অনুপম বৰা এজাহাৰকাৰীৰ পৰা অতি চতুৰ কৌশলভাৱে বেলেগ মাটি বিক্ৰী কৰিবলৈ বুলি এজাহাৰকাৰীৰ পৰা চহী আনি চক্ৰ বিষয়া কাৰ্যালয়ৰ মণ্ডল প্ৰবীণ দেৱনাথৰ পৰা আৰু চক্ৰান্তত কৰি মাটি বেচা কিনা অনুমতি লৈ জামুগুৰি নিবাসী ভাৰ্গৱ জ্যোতি নাথক অধিক মূল্যত বিক্ৰী কৰে। So in the FIR we have alleged that this FIR, this
But
SAID has been
one point
registered.
is there, Mr. Sharma raised the issue that you appear before the sub-inspector of the office, signed in the sale permission, even the sale date.
In the pretext?
Yes, with the impression that some other land will be sold to so and so, as your son has some financial problem. Now the question is, Mr. Sharma raised the issue, where is the other land? Have you brought the land into picture neither in the title suit nor in the FIR lost by you? Obviously, but when you have appeared
if
in
nothing
a
is
title suit or a case is assessed, where is the other land?
In fact,
have you mentioned, have you described the other land?
In fact,
nowhere it has been described.
In fact, the defendant, some objection has been raised that that Pradip Devnath has been made party without giving 80 CPC notice. So therefore, the suit has been itself dismissed. Now,
suit already dismissed.
Suit has been dismissed. They have preferred appeal. Yeah, there is no suit also.
At present, as of today.
As of today, there is no suit also because the suit has been dismissed due to not giving any notice under section 80 CPC. Though he has not been made party in that capacity of Mondal, but Panel Trial Court has dismissed the suit. But suit has been filed for cancellation of the sale deed, and the FIR has been filed regarding the cheating portion. So whether if now he is saying that there are some other land, there is no land, there are and this and that. But these are matter of trial only. These are matter of investigation. So let the police investigate the matter. If there is found nothing is found, police will file FIR against this case. If investigation is itself stalled, he will be seriously prosecuted. And I have already
there is
shown
no order of stay of investigations.
No, there is no.
Still going on.
Still going. And I have already shown that 68 lakhs rupees, 50 out of 68, 58 has been paid in cash. He is a public servant, and rest of the amount, almost 10 lakhs, has been paid to two persons who is one of the accused in the FIR and wife of the accused. So what is the purpose behind all this? So here, my clear instruction is that he has not received anything. In fact, in the suit also, he has mentioned that I have not received anything. The pre-registration summary, the phone numbers are even different.
Whether you have denied receiving money?
Yes.
Where?
In that suit. In the suit, I have shown case 43. Case 43. Sorry, 44. Case 44.
Where is it?
Case 44. Just above the 9th paragraph. Just above the 9th paragraph. The plaintiff also never received any consideration amount in respect of the sale of any land from the defendant number 1 in any manner whatsoever. I have regularly mentioned in my suit that I have not received any money. In the agreement, the tag number has been mentioned as 607, Porta number 345 at page 65. Page 65. Page 65, schedule. Tag number has been mentioned as 607, Patta number 345. Even another interesting fact, clause 7 in the said page itself. In case of unfortunate death of the vendor, his son Anupam Borat, the power of attorney will give register of the land at the same price and the agreement so and so so. So this Anupam Bora is the mastermind, and in connivance with him, they executed all this sale. And in the I have shown the DAG number of the agreement for sale, and page 73. Now the DAG number has become 804, page 73. Page 73. Now the DAG number is 804, Patta number is 486. From agreement for sale, from to sale deed. And in fact, in the sale deed, the old DAG number, Patta number has not been mentioned. Whenever we, in this type of situation, you used to put the old DAG number within the bracket and new DAG number. So there is no mention regarding all the old DAG number and new DAG number.
We have not mentioned what they will do. It is you have not mentioned.
No, he has purchased the land. In fact, I am always denying that I have executed the sale deed on the pretext of some another land and 80-year-old person. It can be always. So these facts are where to be investigated. Then if there is nothing is found against him, it will final report against.
Yes.
This case, my lord, here accused, one of the accused person, Anupam Bora, is also during investigation, my lord, while the police has, three files from the circle location, which were, my lord, at the time of then now, my lord, to point land sale for obtaining land sale permission, my lord, as point photograph of the seller required. One affidavit for my lord and the participated of the participated. Here, my lord, admitted position is that land is in the name of the my lord, not in the name of. Now, my lord, during investigation, police has seized, my lord, and joint photograph and mobile phone is used. And now I have received Israeli report, the FSL report, my lord, those signatures of the Anindra Kumar Bora, my lord, in an affidavit, which was, my lord, submitted at the time of land sale. Regarding that, from the FSL report, I would like to point out, result of the laboratory examination. The documents in connection with the above mentioned case have been carefully and thoroughly examined and compared the disputed signatures with the supplied standard writing and signatures in all aspects. The person who wrote the blue enclosed writing and signature stamped and marked S1 to S4, those signed by the Anindra Kumar.
In where?
The affidavit which was submitted for land sale permit. Not write the red enclosed signature, similarly stamped and marked Q1 and Q. Anindra Kumar Bora has not made his affidavit which was submitted for obtaining land. is the FSL report regarding the signature in the regarding that physical photograph, joint photograph mirror, that could not be ascertained by the FSL because one physical that was only relevant. However, there is forensic software available in our laboratory to determine the presence or absence of manipulation or editing in a digital image. The case may be sent back afresh to our laboratory after collecting the affected original digital image. Yes. However, as stated by the expert of the division, there is no specific tool and relevant procedure available in this laboratory at present to check the presence of manipulation or editing in a physical copy of photograph. So that joint photograph regarding that, my lord, FSL will be able to ascertain regarding the my lord, this is regarding my lord signature in the affidavit and the joint photograph which was submitted during land sale permission FSL. Regarding mobile phones, will could not yet mobile phones of the accused. Otherwise, my lord, statement of the Mondal, who is an also an accused, my lord, his statement is also available and he has also, my lord, stated that at that point of time the accused person, my lord, as per the instruction of the accused person, they, my lord, also execution of the sale deed was done probably by way of execution, my lord. Physical presence of the Kumar Bora was not there at the
Who said this, Mandal?
Yes, your lordship may kindly peruse the statement of the Mondal, my lord.
Nowadays, one photograph of both buyer and seller is required in the land plot of land itself. Now it is required, but he was not there. As per the report of the mandal or as per the statement of the mandal, that only Bhargav Jyoti was there, whose photograph was there, and
Whether it was edited or not,
he was not present at the time of measurement or at the time of taking photographs.
but regarding the at the time of execution of the sale deed,
One joint photograph is there.
not execution at the time of execution, at the time of for obtaining sale funds. The sale deed at the time, sale deed is not there in this case. About the sale deed, but whether he made it or not, I think that aspect there is nothing there in this. But regarding before my lord, final execution of the sale deed, whatever the procedure of the my lord, those documents were seized by the police for obtaining sale funds and everything. And my lord, regarding that aspect, before obtaining the for execution of the final sale deed, these are the materials, these are the documents which will be required for
Yes. These aspects are still under investigation. Yes, okay.
You may kindly come to page 75.
No, your part has already been over. What do you want to submit? More?
More, Lordship, just want to
Yes.
reply to their.
Just for 5 minutes only.
Yes. Come to, Lordship, come to page 75.
Yes, 75.
This photograph taken by the registry is available, Lordship, the vendor, with his thumb impression. It is part of the deed of sale. Secondly,
maybe my lord, on the city temporary, although that document is not a very changed. Suppose my lord, so far because his son is my lord there, is also by my lord in any manner his son, because of that my lord ultimately suppose he makes business because everything was done by way of supposing commission. At that point of time,
no, execution was done in front of the registry. Everything was done in front of the registry. The person was physically present. His photographs are there in both the agreement and the sale deed. Secondly, regarding that phone number, Lordship, that phone numbers are different. It may be 2-3 number may be different because your Lordship may see page 76.
But you want to submit that the phone numbers which have been collected are not the phone numbers of yours.
What
It
they are
is not
saying
your phone number.
No, they are saying that it belongs to my phone number. Both the
You
phone
are
numbers
saying
are
that
mine.
you
Yes,
phone
Lordship.
numbers are not yours.
Yes, Lordship. Both the numbers are different. How can it be mine, Lordship?
especially it seems that he has submitted that it was not on commission before the registry.
It was done before the registry.
Before the registry, then definitely my lord Surendra Kumar Bora has to be present there. But otherwise, without his absence, then
And
how registry can make the then my lord all these things, statement of the register, my lord, and other parts of the registry, also those things need to be
required.
Then regarding non-payment of the amount, Lordship not receiving any amount, may I kindly see annexure 8 at page 69.
No, you have already submitted.
No, Lordship.
Your submission is there.
No, that money receipt is there, Lordship, with the signature of the seller, Lordship. Page 69. This is the money receipt. Surendra Kumar Bora accepted to have received rupees 68 lakhs. Below he is the signature. And Lordship, regarding that 3 DUG number and Bata number, the FIR is very clear. Lordship, may kindly see page 40.
No, you're going to hear again.
No, that's just 1 minute, Lordship. That in the FIR itself, the informant that the petitioner has stated that this new number has been received after Batwara. So there definitely will be 3 phone number
in the WS, we have clearly stated that earlier they gave a wrong DUG number and pattern number. Therefore, after rejection of the permission, this new number was given. So there is two DUG number and pattern number in agreement and sale deed. And the third DUG number and pattern number obtained after Batwara. So three separate DUG number does not mean that I have committed any fraud lordship there. And thirdly, that regarding that signature in the affidavit was done by the son. What I am, the permission was applied by the vendor. So who put the signature on that affidavit? I am not liable for that lordship. Definitely,
My
part is not there, Lordship.
Lordship.
During
We have-
investigation, purchaser may not. I am just
Because
for a moment.
the first portion of the
Purchaser may not be involved. Well, later on it will be proved, my lord, during course of it, because investigation is yet to be completed, my lord, and my lord, otherwise, my lord, because of that Anupam Bora, he is the probably main, my lord, problem, my lord. Otherwise, suppose whether the present purchaser is involved with Anupam Bora or not, my lord, during some later stages of investigation, everything will come out. Later on, if suppose, my lord, there is no materials found against the police will submit final report against the agent. But at this stage, my lord, without taking those evidences of the register, and because admittedly, my lord, ultimately, my lord, it seems that execution was done in the office of the register, and both purchaser and seller maybe were present. But before the execution of the sale deed, but in some of the documents which are essential, ultimately, my lord, execution of the final sale deed was the allegation. So things that we look into. If there is not at all responsible, police will file. Passing may be done in my favor. Let the entire affair reveal, because in the first part of regarding this fraud, my name is not nowhere mentioned here. Entire allegation goes to the son. It is by the informant itself that the
Son.
yes, Lord, not by the purchaser. And I have paid rupees 68 lakhs because there his money receipt is there. By paying rupees 68 lakhs, I have been put under the bar. And now this FIR, he is a government servant. He is working in postal department. So Lordship, the FIR may be passed against him, and then it may remain. Obligatory.
I heard Mr. R. Sharma, he left also for the petition. Now, Mr. B. Bot. It responded number. And Mr. D. Chaudhary, the Learned Council appeared for the respondent.
Yeah, I'm providing one judgment. There are 14 and 15 may be looked into. Lordship.
Then application for washing of the FIR dated 4/3/2025, being this for PS case number 159 in the section 318, section 3, 316 subsection 296, public 74, public 3, subsection 5, PNSS, responding to GR case number 87. Mr. Sharma, the learned for the petitions that the present petitioner had purchased land measuring 1 less from the informant of this case, by wherein the sale consideration amount was of rupees 68 lakhs, and after and accordingly one sale agreement was initially executed by the respondent number 2, and thereafter the sale deed was executed after obtaining the sale permission from the department. Entire sale consideration of rupees 68 lakhs has also been paid to the respondent number 2, and in that regard he also issued a money receipt which has been annexed along. He further submitted that after the execution of the sale, when the petitioner visited to the place of to the land in question, for some construction. The informant of the respondent and his daughter resident, and also like to on which he earlier lodged a FIR, which has been registered as registered as Tezpur case number 148 of the that has already been charge sheeted in the present informant. It further submitted that, and that the suit was also instituted by the respondent number 2, wherein he made the present where he made the petitioner as a defendant along with the son of the informant as another defendant in the same suit. In the said that the petitioner had also submitted a written statement bringing all the materials on the said that the suit was filed for paying for cancellation of sale deed, which was executed in favor of the petitioner by the respondent of the state. He further submitted though the respondent number 2 is claiming that he gave signature on for sale permission as his son was asked for financial help and to sell another plot of land in the Tezpur town itself, but he never put any signature nor applied for any sale permission for execution of sale deed in respect of the land in disputed land or the land in question. Disputed. Mr. Sharma further submitted that initially at the time of giving the sale agreement for sale, the respondent number 2 deliberately put the old tag and patta number, and on the basis of which the sale permission was applied for. But as there was a differences in the tag number, the earlier prayer for sale permission was rejected, and thereafter getting the new tag and patta number, the fresh permission for sale was obtained, and accordingly the sale deed was executed. The further submitted that the informant personally appeared before the office of the sub-registrar in 2 occasions, initially for sale permission and thereafter at the time of registration of the sale deed. And after obtaining after execution of the sale deed only, he raised the issue and prayed for cancellation of sale deed through the tax suit which has already been instituted by him. Also, the plaintiff never denied of receiving rupees 68 lakhs as a sale consideration amount for the land in question, and only prayer made the petition in the title suit is for cancellation of sale deed. He further submitted the end from the facts of the case. It is seen that basically the suit is a civil suit, and there is no criminal liability against the present petitioner for continuation of the criminal proceeding against the present petitioner. If any fraud has been committed, if there may be any fraud, there may be any fraud or connivance with the employee of the sub-register in executing the sale deed, but the present petitioner is not at all involved in the said fraud, and he is a genuine purchaser and purchased the land by paying Rs 68 lakhs to the respondent number 2 of the accordingly, Mr. Sharma submitted that it is a fictitious the uh, wherein the FIR FIR may be set aside and paused in respect of the present petition. You are relying on which paras here?
Para 14 and 15, Lordship. There is reference to some other cases.
14 and purely submitted that the case is purely the nature of the case is a purely civil in nature, which is maliciously being given a color of criminality, and he further submitted from the statement made in the FIR itself, it is seen that case is of civil in nature, and hence the liability to be set aside, and hence the FIR against the present petition is liable to be set aside and paused. In support of his submission, he also relied the decision of the Apex Court reported in 2025 SCC Online SC 1575 versus book versus and basically emphasized on para 13 and 14.
14 and 15.
Sorry, 14 and 15 of this nature. Next, Mr. Chaudhary, the learned counsel, learned the respondent number 2 oblique informant submitted in this way. That is, it is a case of cheating, wherein the old person of 80 years was cheated by the present petitioner in connivance of his own son and the employee of the sub-registrar, office of the sub-registrar. Further submitted that the respondent number 2 never executed any sale deed or nor he entered into any sale agreement for sale of the land, disputed land in favor of the present petition. However, it is a fact that he put some signature on good faith which was produced before him by his son, Anupam, stating that for financially he has to sell a plot of land which is located in the dispute town. On good faith, he put his signature in sale permission, but thereafter he did not execute any sale in favor of the petitioner. So he participated that this plot of land was kept for future of his daughter, and thus the question of selling the said property also does not. Where he also instituted civil suit for cancellation of sale deed, which was fraudulently exhibited, which is forced and was fraudulently obtained by the petitioner along in connivance with the other officials as well as his son, Rupam, and for which he had already instituted a title suit. But they said that suit is not in existence at present. That has already been dismissed for want of section 80 CPC notice to one of notice. It is the observation of the court that one that the Lakmandal has been also implicated as a party defendant in the state suit was not state suit, but before implementing him as a party, there was no notice under section 80 CPC, and for which the suit was presently dismissed by the learned trial. Further, he submitted that he never received any sale consideration amount of 68 lakhs as claimed by the petitioner, and he brought these materials in his title suit filed by him, where he paid for cancellation of the sale. Mr. Chaudhary further said the case is still under investigation and hence submitted that the quashing of the FIR against the present petitioner will cause prejudice to the respondent number 2, who was cheated by the petitioner and by his own son in connivance with some of the officials of the sub-district. Next. Mr. Bottom, the learned additional people submitted in this report that police had seized some documents and the sale permission and the sale did vary. The joint photographs of the informant, joint photograph of the petitioner and the respondent number 2 is available, but due to non-availability of some technical facility, the joint photographs is already sent to the FSF, but report is not received till date as to whether any manipulation took place while producing or attaching the joint photographs in the sale deed of the sale commission. Also, the FSL, the mobile handset which were seized in connection with this case, also sent for examination to FSL, but report is still awaited and investigation is still under process. However, the signatures which were put in the affidavit annexed along with the sale deed of the sale permission does not belong to the no does not is not the signature of the respondent number 2 as per the handwriting expert, which has already been received by the I during investigation. Next, Mr. Waterford further submitted from the statement made by the Latunda is also seen that the present it's seen that the respondent number 2 was not present at the time of taking photographs in the over the disputed land, and when he came to the where he came there for measurement and taking photographs along or of taking joint photographs of both the seller and the buyer. Mr. Bottom further submitted that the investigation is still under process, and in the event there is no case, in the event the case is not proved against the present petition, there is probability of furnishing the final report against the present petitioner, but as the case is still under investigation, there should not be the the FIR against the present petitioner may not be used at this point. Next. During the submission made by learned counsel for both sides, I have also placed a scanned copy of the case diary and the other connected other other annexed filed along with it. Next one. It is a case wherein the petitioner brought the allegation that after receiving the sale consideration amount in full and after executing a sale deed in his paper, the respondent number 2 denied of such execution and to harass the present petitioner had also instituted a title suit along with FIR bringing some false and concocted allegations. Further, it is their claim that prior to the lodging of the FIR, prior to the lodging of the FIR by the respondent number 2, the petitioner had already lodged an FIR which has already been charge sheeted against the respondent number 2. On the other hand, it is the case of the respondent number 2. Respondents that the petitioner, in connivance with the son of the respondent number 2 under officials of the sub-registry, had fraudulently prepared a sale deed wherein the fraudulent prepared wherein he never executed any sale deed in respect of in respect of the land in question. From this CD, it reveals that the case is still under investigation, and the affidavit and the signatures and the disputed signatures of the affidavit were also sent for examination, which gave the negative result with an observation with a report that the signatures available in the affidavit annexed along with the sale permission sale deed is not the signature of the respondent number 2. Further, as per from the submission made by Mr. Potter as well as from the materials in the case diary, it is also seen that the FSL report for the mobile handset are still awaited, as well as the report from the FSL report from the laboratory is also awaited awaited regarding the report from the FSL regarding the joint photograph. Regarding the genuineness of the joint photograph is still awaited, which is still awaited. That the manipulation of the joint photograph could not be ascertained by the laboratory. But it is a post-op. It is an admitted fact. There is that one title suit was also instituted by the respondent number 2, seeking cancellation of the sale deed. Cancellation of the sale deed, but subsequently the title suit was dismissed for want of Section 80 CPC. It may be a case that the petitioner may be a genuine purchaser who claimed that he had already paid the entire sale consideration of 68 lakhs to the present petitioner, but seen that there is, but disputed fact is that the respondent number 2 public informant had claimed that he never executed any sale deed conflict the sale permission in the name of sale permission in favor of the present petitioner in respect of the property which has been mentioned in the FIR as well as in the title suit. Thus, it is seen that there is, thus it cannot also be denied at this stage that there is an ingredients of cheating as well as the criminal and the criminality of and the criminal color of the ingredients of cheating present, which is still under investigation as to, and the involvement of the present petitioner will come out only after the investigation of this case. But from the statement made by the Gatbandhan, it is seen that in absence of the petitioner, in absence of the respondent number 2 in the land concerned land, the photographs was managed and it was assured by the co-accused Anubhav that he will produce the joint photograph of the respondent number 2 and the petitioner at the time of the applying for sale permission as well as in the registration of the sale. Thus, prima facie, it is seen that the sale permission and the sale the joint photographs in the joint photographs at the time of sale permission was obtained without physical presence of the respondent number 2 over the land in question. It is a settled law and there are various judgments of the Honorable Apex Court that the case which is basically civil in nature, it was whatever. Though there are some civil disputes between the parties, but the ingredients of cheating and other criminal offences cannot be denied at this stage, as the case is still under investigation and there are still under investigation. So at present, it cannot be held that the entire case is exclusively civil in nature to quash the FIR against the present petitioner at this stage. In view of above discussion, so and so, it is held that that it is not a fit case to to quash the FIR against the present petitioner at this stage by invoking the power under section 520 BNSS. Same statute. Your petition stands rejected at this stage.
See, the allegation in the FIR, it was not against the petitioner also, not. Because the entire allegation goes against the son of the informant.
What to do?
About that, that cheating.
They did say your probability is also there for final form. You are on bail, I think. You are on bail.